I'm not stepping out of the vehicle until you tell me the reason. I reserve all my rights.
At any time, was I Mirandaized?
And he said that I lied to him like all women do.
That he made a statement, fuck no, I'm going to beat that bitch.
You don't think it was just retaliation for the false arrest?
Door has been opened, not just open, but flung wide.
We, the jury, found the defendant
guilty. They found him guilty. That's no spoiler. It seems like the jury took 15 minutes to convict, but in reality, by the time they got in the jury room, picked a foreman and sat down, they needed 30 seconds to vote unanimously. This is Sherrick Vaughn. You may remember him from a video I did 4 months ago in which he tried to fire everyone, starting with Judge Wolfe. That didn't work, but he did decide to represent himself for these motions and this jury trial. And for that, I am thankful, because without that, the motions hearing and trial you're about to watch wouldn't have been nearly as entertaining as they are.
Motion to squash.
I spent considerable time cutting out duplicate testimony and body-worn footage to bring you the best of watching this SovCit adjacent wanker lose. Let's roll, nerds.
This is the state of Tennessee versus Sherrick Vaughn. We have a number of, he has, I think, 4 different indictments. Case that's set for Friday, is charge of driving a revoked license, third offense, and resisting a stop, frisk, halt, or arrest or search. And then count 3 is retaliation for past actions.
The state was already planning to go ahead and dismiss count 2 of this indictment, which is resisting arrest. State will continue to go to trial on count 1 and count 3, but that should shorten the argument some.
All right, so the state is moving to dismiss count 2.
Yes, Judge, which is the resisting arrest.
So count 1 is driving a revoked license, third offense, and count 3 is retaliation for past action. Mr. Vaughn, do you understand that the state has moved to dismiss count 2 of this indictment? So you need to turn your microphone on there.
For fruits of the poisonous tree, they need to dismiss the rest of them because that was the reason I was even arrested to begin with.
Well, I am going to let you argue your motion, and
Your Honor, can I get a hand free so I can find my paperwork, please?
you may.
Your Honor, while he's doing that, may I address the court, there was a motion to quash the indictment in this case, and a bill of particulars motion, is that right?
There was a bill of particulars that was filed, a motion for a request for a bill of particulars filed March 27th of 24. And that contained, addressed 4 different indictment numbers, including the one for Friday, 336. The motion specifically addressing 336 is a motion to quash or dismiss with prejudice / suppression. And that was filed July the 7th of 2025.
All right, that's the one you're here to hear today, you said?
That is the motion that I'm going to hear today.
You said you want me to
You may.
Your Honor, why wasn't I given notice of today's court date?
Number one, you filed these motions, and this is the first opportunity that we have to hear these motions or this motion prior to your trial date. I'm assuming you don't want your trial date continued from Friday, since you had filed a speedy trial motion.
Yeah, and I'm still stating the same thing on the record, that that is not what we were supposed to go to trial on. The last time I was here, it was for the case in Dixon over with Jennifer's mom. I forget the case number. There you have the case number. She didn't speak about going to trial on this one. The state changed it without giving notice again.
I'm sorry?
I mean, it seems like it's a hindrance to my defense when I don't know what we're going to trial for when I'm coming in here, and I'm told one thing and it's another thing when I get here, and I'm not even giving notice that I'm here today. Like, I wasn't expecting to be here until Friday, and I just filed 2 more motions that would have made it on time within the time limit that's required by the local rules of practice. I got them with me. I'm kind of caught off guard here today. The reason I'm trying to get out.
What are those motions addressing, Mr. Vaughn?
It was another to recruit Mr. Lee Spratt, and it was another to address these charges here today too, where there was some dismissals back when I first was arrested. And them dismissals still showed up on my Homeland Security report that it caused another arrest in another county. It was it's a motion to arrest judgment on that. That's yeah. So I feel like I'm getting caught off guard here.
Well, your motion to dismiss or quash was filed, and this case is going to trial on Friday, so I have to hear it before the trial. To not do so would basically mean that your case would have to be continued, or you'd have to waive your motion.
No, I'm in full understanding of that. Yeah.
I'm trying to give you an opportunity to have that heard and make a ruling on the record of it so that, you know, you preserve the issue prior to the trial date on Friday.
Okay. Do you also have a motion for chief evidence up there with you?
A motion for what?
For the state's evidence in chief?
I think there is a motion such that you described, but it is not addressing this indictment number.
I should have one for all of them, and including with this, is the state not required to respond to me? Because I've responded way before the state responded. She didn't even give me a response to this motion. I'm just filing this, and I'm.
State does not have to respond to the motion until they come to court. They can then respond on an oral argument.
And then I can have a response after that, correct?
Yeah, I'll give you a chance to respond after they do.
Okay.
But you do have a motion to preserve testimony or a motion to subpoena someone, and that is to subpoena Jennifer Dozier.
Yes.
From Savannah, Tennessee. Was there a subpoena issued for Ms. Dozier in regards to his, well, he had requested that there would be a subpoena issued for Jennifer Dozier to make her testimony at the motion hearing date. All right. I want to deal with all of the issues that relate to 336 that are set forth. First one is the motion to preserve testimony or subpoena this witness. So let's deal with that one first.
All right. Hereby I, Sherrick Vaughn, come to move the court to subpoena Jennifer Dozier. I have her phone number, which is listed. Her address is also listed to preserve testimony in the above case and motions to dismiss. She has first knowledge on each pending case. I move the court to subpoena Jennifer Dozier and make testimony at the set motion hearing date. This is the motion I filed for you.
Okay. Why do you need Jennifer Dozier subpoenaed?
Well, Jennifer Dozier is the mother of my children, and we were also living together. And every time I was arrested, she was present at every scene, and she can verify to my testimony of each case, like the illegal arrest, non-resistance, illegal search and seizure, twice and two separate. She can testify to every single thing I'm stating.
All right. In regards to the case on Friday, which is basically a driving on a revoked license, third offense, and retaliation for past action, how does her testimony factor in on those two charges that we're dealing with on Friday?
On those two charges, I mean, I would say it would still tally in if we add back in the charge they're moving to dismiss, because like the motion states itself, that it'd be fruits of a poisonous tree, that they need to dismiss it because it was a illegal arrest from jump. I should have never been put in handcuffs or arrested or nothing. And she would testify I never resisted or anything. To take that one charge and just press it to the side and then keep the rest, it'd just be unlogical.
Well, I understand what you're saying, that she may have been present during some of the proceedings, but is she going to be able to testify about anything that has to do with whether or not you were driving or not driving a motor vehicle while your license was revoked?
I feel like that's a trick question, Your Honor.
Yeah,
like you're probably trying to perjure me, aren't you?
It probably is a situation where you don't, because you're representing yourself. Well, obviously, we cannot get a subpoena issued and served on her at this point in time. Do you have any contact with her?
I do, and she would be a material witness, Your Honor.
And being a material witness, then you would be entitled to a continuance for the case on Friday if she's not present.
How long is this continuance, Your Honor? I'm so tired of these cases. I don't want it to be out months at a time again.
September 25th
I'm trying to think, Your Honor. I also have Decatur coming up.
Decatur's on September the 30th. I just got it.
It's the 30th. Okay, that'll work. Is there any way we can also add in this other motion about getting heard about the Homeland Security stuff that was supposed to be dismissed?
Well, that really doesn't have any relation to what I'm doing today. What I want to do is deal with what I have to on this case, what I'm trying to do. He has requested a subpoena to be issued from Ms. Dozier. He is entitled to have that witness subpoenaed. I don't find that there was one, even though I think it was probably just a series of motions that got filed and it just got overlooked. So I want to give him an opportunity to bring this witness in to have her testify if he thinks it's relevant. So I'm going to move your motions to Friday to give a chance for you to get in touch with this young lady that you want to have brought in and see if she will come voluntarily. And I'll have the clerk go ahead and issue today a subpoena for her at the address that you've shown in your motion, but they may not be able to get it served on her, but if you'll contact her, she can be served with it if she'll voluntarily appear. And we can set your motions for Friday.
Yeah, that's frustrating, Your Honor. I mean, these motions been in. I mean, it makes no sense. I mean, she's prepared, but I ain't.
Well,
That's very frustrating.
resetting it to Friday is going to give you a chance to prepare, and you know
It
which
is,
ones.
but it ain't. It is, but it ain't. I mean, these motions been filed for 4 months. I mean, I don't understand why people just can't read the paperwork and do it.
Well, even by the record, they were filed July the 7th, so they're not been filed 4 months. Let me go ahead and just say that we're going to continue the motions to the 19th this Friday, and we're going to have the trial moved to the 25th. If, General, you may file your request to have a witness appear by Zoom according to the rule, and we'll have a hearing on that on Friday as well.
Well, if that's the case, Your Honor, can we go on ahead and get my other one added in too? I mean, because the reason I keep asking about this motion, this pertains to me in Decatur.
Well, let's just hear all your motions on Friday.
That sounds good.
Pardon? On every case, we'll hear every motion he's got.
That sounds great. That's great, Your Honor.
State would call Sergeant Justin Stewart. Did I get it right? Sergeant.
Sergeant, if you'll come forward, we're going to put him over here.
Did you work a call involving the defendant, Sherrick Vaughn?
Yes, ma'am.
And at the jail later on that night after his arrest, did you encounter Mr. Vaughn again?
Yes.
Could you explain to the court what happened?
We made an arrest later in the shift, and while we were at the jail to deal with our arrestee, jail staff pulled Mr. Vaughn, I believe, out of the holding cell he was in, and he was upset still at that point, agitated, and he made a statement, something to the effect of, I've got bullets for all of you, or enough bullets for all of you, etc. So I just mentioned to Officer Javvens when I returned to the police department that was worth notating in her report, just in case in the future, if she were out in public, you were to, attempt to follow up on those threats, the documentation would be there that they were made.
Nothing further, Judge.
Mr. Spratt or Mr. Vaughn, either of you have any questions for this witness? Come to the podium. And I would, again, Mr. Vaughn, I know you've are pretty well acclimated to the law about a lot of things, but you must ask it in the form of a question.
Yes. Give me a second. How long ago was this case, Mr. Stewart?
2022. It's been a while.
2022. So you have full, you remember, have no problem remembering what happened?
Yes, as I said, me saying it, the phrase or the terminology of enough bullets for all of you, or names on bullets or things like that, I'm not 100%. I do recall it being concerning enough that I went back and told my officer to document it just in case you actually meant it and weren't just, upset in the moment, and may actually try something later.
So that's what you're standing, you're sticking to it. Like
100%.
you're fully remembering
Absolutely.
that.
Yeah.
Do you have any video footage of this?
So we're working on that right now. We initially thought that my video footage was tied to Officer Javvens' original case with you, with the traffic stop. And then it was learned recently that no, in fact, my footage was not from me being present for her case. It was a separate case that we had afterward while Officer Javvens wasn't at the jail.
So you don't have any footage?
Of my own body cam at that time, no.
Okay. Is there any jail footage that you know of?
I'm not sure. I know, as I said, Officer Floyd was there with me, and then of course some of the jail staff would have been present.
Okay, and you said they pulled me out of the cell and I made these statements?
If I'm not mistaken, I know you were standing in the area in front of what is now Male Detox 2. They have a blue square on the wall to photograph people. I don't remember if they had just pulled you out, but I remember you being out of the cell in the open there when it was set.
Okay, I rest, Your Honor.
Yep.
Go ahead.
Moment, Your Honor.
Yeah, consult with your co-counsel.
Sergeant.
Sergeant,
That's fine.
I'm sorry. I always want to clarify. You said that he was pulled out of the cell and made the statement, "I got bullets for all y'all," right? And that's exactly how he said it?
Yes.
Okay. So he never mentioned Officer Javvens specifically then, did he?
I don't think he explicitly stated it was her. It was
Okay.
just law enforcement.
All right. So, well, did he say law enforcement?
The only other people in there would have been law enforcement. So I just logically, yes, sir, that's who he's talking about.
But none of them are named in this indictment, correct?
I don't believe so.
Okay.
Anything else, General, for this witness?
No, Judge.
All right, thank you, sir. You may stand down.
Thank you.
For the purposes of the hearing today, we were preserving all of the other motions for Friday. So if there's nothing else, then we'll adjourn this case until Friday.
Your Honor, one more. Would you consider those motions that you probably haven't received yet? Consider those as moot. I have, except the motion of indigency. You can keep that one. I just don't want to add no more time to the fast and speedy trial. So if we can't get them heard, I just want to consider them as
If
moot.
you have motions that you're going to file, make sure that Mr. Spratt assists you in filing them, and we'll have everything heard on Friday.
They're already considered filed by the rules, sir. Once they're put in a correctional facility now, they're considered as filed.
You want what?
Considering the Rule 49, they're already considered as filed. I'm just trying to get them considered as moot today.
Well, I'm not hearing anything else today to allow you to have an opportunity to prepare everything to be heard on Friday. As the trial date is being moved, we're going to give you the whole day of Friday if necessary to hear your motions.
All right, thank you.
All right. All right, we are here today on the State versus Sherrick Vaughn, and we have a number of motions that the defendant has filed pro se. A request for a criminal record for the defendant requested on April the 21st of 2025, a copy of his own criminal record. That would normally be supplied in discovery. Has that been supplied to the defendant?
Yes, I have received it, Your Honor.
All right.
Can you hear me?
Is that microphone on? All right, thank you. So that one has been complied with. All right. On April the 21st of 2025, you had requested to remove your elbow counsel or your counsel. You're okay with him continuing as the elbow counsel. You will be representing yourself, correct?
Yes, sir, I will. And yeah, you can strike that motion. I've received all discovery.
All right. And we'll show that has been complied with. On May the 9th of 2025, there was a request for a recusal of the master clerk. We want to represent yourself, and I've granted you that opportunity.
21, I'm tired of coming here looking at y'all.
You filed a motion to recuse, notice of recusal or request for the master clerk. You had a motion to recuse the court recorder.
Well, recuse yourself because you're not doing it.
My understanding was that was based on some objections you had. I have denied that motion. On May the 9th, you had a motion for recusal of the court reporter, and I believe I have previously denied that as well and would deny it again if it were renewed. On May the 9th, there's a request for a copy of records and file. A copy of the entire court file and record is what I'm understanding. Is that an issue that we need to address?
I believe that the discovery, I think we actually addressed that already too. Unless there's something that I'm not aware of that's been filed into the case.
I believe that everything that would have been relevant has been supplied to you, and we'll go ahead and do that. On July the 7th, you filed something called judicial notice. Does not appear to me that that's anything that we need to argue. But then on July the 7th, you also filed a motion to quash or dismiss the indictments against you, and I think that is where we are today. Familiar with you had indicated you were going to file some additional motions.
Yes, sir, they're filed. I believe the state has a copy of them.
All right, I have two motions in my hands. Well, one motion and one something else. First motion is a motion of indigency where Mr. Vaughn is alleging that he is indigent and therefore he's asking that the court find him to be indigent. Second is a document he has styled arrest of judgment. And it says, I, Sherrick Vaughn, come before the courts of Dixon County on April the 7th of 2024, dated the attached document you can see I have on my record of driving on suspended charge for failure to appear out of this court labeled Exhibit A. This failure to appear came out of this court, a charge that was dismissed. I pray that this error is amended and the proof of amendment be promptly provided to me. I'm not sure exactly how that relates to what we're dealing with today, but
That pertains to one of the charging instruments out of this court, sir, on this case right here. Your Honor, I got one more for you. It's a judicial notice for you.
all right, this is styled a judicial notice / notice of objection to the state's failure to file a written response to the motion to suppress. And then you go ahead and cite under Rule 47 of the Rule 49 of the Rules of Criminal Procedure that a response is to be written unless otherwise permitted by the courts. And you're asserting that no written response has been filed by the state as of the date of this notice. No oral response was authorized by the court. In the absence of a written response, prejudices the defendant's ability to prepare for the hearing and address the state's argument. Therefore, you as a defendant requested the compliance of the service and filings of pleadings required under Rule 49C shall be stricken from the record, and Rule 47 take notice of the state's noncompliance, limiting the state's argument to those properly raised in writing. Grant any other relief.
I have some questions for you, too, before we start, too. From my understanding, you told me any more motions that need to be filed into this court need to be filed through my elbow counsel. That is a prejudice to me defending myself as a pro se litigant. If that's still the order that stands in this court, then that is denying me access to the record, Your Honor.
What are you saying?
That is denying me access to...
What are you objecting to?
I'm objecting to the order that you gave on Monday that any more motions that need to be filed through my elbow counsel.
I don't recall making such an order, Mr. Vaughn. I recall suggesting that you get with Mr. Spratt and that you and he, or that he assists you in doing that, but I never ordered that you had to file it through him.
Okay, then it's understood then.
All right, your motion, you may argue it.
I'm requesting for the courts through this motion that any improperly filed motions, any properly invited witnesses to this case and any testimony that should be taken into this case be stricken from the record or not granted due to the fact that I was not given proper notice to prepare a defense. If you see any other justice to be served, I suggest you go ahead and make a ruling on it.
All right, I'm prepared to make a ruling on it. Rule 47 of the Tennessee Rules of Criminal Procedure, you're arguing that the state was required by law to file an answer to your, in writing to your motion, and that if the failure to do so means that they could not present any proof. However, Rule 47 of the Rules of Criminal Procedure provides the following. A, in general, a party applying to the court for an order shall do so by motion. B, form of motion. A motion except for one made during a trial or a hearing shall be in writing unless the court permits it to be made orally. That's the motion. There is nothing in that order, in that rule, that requires the state to file a written response to your motion to suppress. Therefore, your motion, your judicial notice / notice of objection to the state's failure to file a written response to the motion to suppress is respectfully overruled, and we are ready to proceed. State may call your next witness.
Excuse me, Your Honor, can I make an objection to that? It doesn't state the request that the DA file a written response, but it does require that the state give notice and of anything that she files. And I've not received a notice of who her witnesses was, or I haven't even been.
There's no requirement, Mr. Vaughn, of that. There's nothing in the rule that you filed under that requires the state to give you notice of the witnesses they're going to call, nor does it require them to give you notice of any writing that they have. And to my knowledge, the state has not filed any written response. Is that correct, General Bronson?
That's correct, Your Honor. But what about notices for court dates? I've twice in this court, I've been called to court without even giving a notice.
There is no validity upon your objection to based on those things, and your motion has been denied, so we're moving forward. All right, Judge will call your first witness.
State calls Corporal Lindsay Javvens. June 18th of 2022, were you working with the Dixon Police Department?
Yes, ma'am.
Did you come into contact with the defendant Sherrick Vaughn?
Yes, ma'am. We had a call for a possible domestic at Walmart that he was making threats to kill the female and the children. I observed the vehicle, same tag, all of that, and I'm at a traffic stop at Dollar General on Beasley Drive.
When you approached the vehicle, who was driving?
Mr. Vaughn. Well, I asked Mr. Vaughn to step out of the vehicle due to it being a possible domestic. I wanted to separate the parties to look into what was going on. He refused to do so. I asked him approximately 8 times to step out of the vehicle, and he refused to do so, even after being told of his obligation to do so. I had to open the door and assist him out of the vehicle. Also, during that time, during the investigation on scene, it was determined that his license was revoked as well.
So you initially arrested him for resisting,
and driving unrevoked.
and the state's not moving forward on the resisting charge, but he's still being prosecuted for driving unrevoked.
Yes, ma'am.
Did you confirm that he was revoked? Did you learn that by speaking to him, or was it something that you ran a system?
It was through dispatch.
He has been charged with retaliation for past action. When was the first concerning statement that the defendant made?
As we were entering the jail.
What did he say as you were entering the jail?
As we were entering the jail, he told me that he was a threat for a reason.
And did you clarify that?
I did. I tried to clarify. I asked him again. He said, I'm a threat for a reason.
And were there any further statements that were concerning to you?
Yes, ma'am. So I had obtained my warrants by meeting with the magistrate before I went to the jail. Got to the jail to serve those warrants, and so he could be booked. I was up doing my paperwork. I'd finished completely, and the jail staff still had him in handcuffs. I told them that I needed my handcuffs so I could go. There was some hesitation with the jail staff to remove the handcuffs, and they went around to try to remove them. At the beginning, I was assisting, and then he became upset because I was assisting because I was touching him. So as soon as more people got over there, I stepped back so that I was no longer touching him. During that time, they were trying to get the handcuffs off, and not a direct quote. We may have to do the video for the direct quote, but he was saying that whenever I got hit in the jaw, that it was going to be their fault because they wouldn't let him go because they were trying to take the cuffs off. Then the female jailer was telling him, like, please stop tensing up so we can get the handcuffs off. And he said, I believe the direct quote was, fuck no, I'm going to beat that bitch up.
Taken all together, did you take those statements to be in reference to you?
Yes, ma'am.
Nothing further at this time, Judge.
Mr. Vaughn, you have the right to question this witness. If you wish to question the witness, you'll need to come to the podium, please. And I would remind you that this is not an opportunity for you to make statements. It is an opportunity for you to make a question.
What did you arrest me for again? What was the reason for your arrest?
Driving unrevoked and resisting.
Resisting arrest was the original reason you arrested me, correct?
I arrested you for driving unrevoked and resisting.
So when you pulled me out the car, you were planning to arrest me for driving unrevoked and resisting, correct?
You were removed from the vehicle, and yes, you were going to go for resisting, yes, sir, but you were also revoked. Whenever I went to the magistrate to present my affidavit to them, that was for driving unrevoked and for resisting arrest.
Okay. Do you believe that your arrest was justified?
Yes, sir.
You believe that you did that to your best of your abilities?
Yes, sir.
You don't believe there was no illegal intent or malicious intent involved in it?
No, sir.
Do you believe that I truly resisted arrest?
The fact that I asked you 8 times to get out of the vehicle and you failed to do so to the point where I had to open the door to get you out, yes.
So did I use any force, resistance, threat of flight, or harm to you?
You remained in the vehicle and did not get out.
So that's a no?
I did not have to fight you, no. After the door was opened and you got out with me.
What was the reason for you wanting me to exit the vehicle?
I was investigating a domestic because I had a call for service stating that You had made threats to kill the female and the children. So I made contact with you. For a domestic, we want to separate the parties to be able to hear both sides. You were asked to step out of the vehicle and didn't do so.
Is that the only chosen method that you could have used, or was that just the one you chose to have me to separate us?
That was the method that I was going to choose, yes,
That
to
you
separate
chose.
you. That is what we do in domestics.
Could you not have asked the alleged victim to step out of the vehicle?
I was asking the driver to step out. I can pick whichever one, and you were refusing to do so. You were the one that was making the threats. I think that it's more pertinent to separate you from the situation than anything.
You keep saying that I was the one to make the threats. Is there any proof that I made these threats?
I had a call for service that you were making threats. I was investigating those threats that were made. That's what I was there for.
So you believe those threats was made by me?
I didn't arrest you for domestic, but because I didn't have any cooperation, but there was a reason that I was called out there.
So you didn't have any proof, correct?
A domestic arrest was not made due to the uncooperation of the victims.
You believe that there was a victim actually in this for the call?
I wasn't called for no reason. That's what I was investigating.
So what I'm asking you, do you believe that she was a victim?
Judge, I'm going to object to relevance at this time. There was no charge for domestic, and so this really doesn't pertain to the motion.
Mr. Vaughn, the objection is as to relevance. The officer has testified that she was investigating a domestic violence case, or at least a domestic violence call, which means that she was there to investigate. Whether she believed there was one or not, is irrelevant. The question of whether there was or was not one is technically irrelevant, because if she is responding to a call of a possible domestic violence, that is her reasons that she's testified to for stopping the vehicle and engaging with you. And at that point, her personal belief as to whether or not there was or was not a domestic violence is not relevant. So I sustain the objection. You may ask your next question.
I'm going to object to that, Your Honor. The relevance said the case. I mean, it was for a domestic. To see how she approaches the situation domestic involves the entire case. It all stemmed from the original call. So there is some relevancy to the fact what was she visually seeing. I mean, she's later on making statements like, what is your view of everything? I want to see, how do you see things? Like, she should be able to answer that question, Your Honor.
I've sustained the objection, Mr. Vaughn, and so I consider your argument. But an officer who is responding to a call almost never knows for sure what is taking place. They're there to investigate. That's the whole purpose of the investigated stage of a criminal case. An officer who responds to a call is given a limited amount of information. They are responding to it in order to make that investigation to determine whether there was or was not a crime committed. And that gives them the opportunity, the probable cause, to engage with a citizen and to talk with the citizen about that investigative stage. And then if they determine there is a crime being committed, then they can do that. But that also allows them to investigate and engage a person, and if they determine that that person has committed a different crime than domestic assault, then the law allows them to engage and charge that person for that. So I have sustained your objection of the state, and I'm instructing you to ask your next question. I've noted your objection, your disagreement with my ruling, but I am telling you, you need to move forward. You preserved your objection, so let's move forward.
Do you believe that you was emotionally attached at any time during this arrest?
Emotionally attached? Can you clarify?
You were responding to a domestic violence as a female to a domestic violence on a female. Do you believe that you were emotionally attached in any way, form, and fashion?
I was doing my job.
Okay, so that's a no?
I was doing my job. I don't hold any personal feelings towards my job. I have a job to do and a law to abide by, and that's it.
Do you recall making a statement that I believe that she is a victim?
I do not recall.
Did you at any time see that you could have de-escalated the situation between you and I at the scene?
If you would have stepped out of the vehicle the first time I asked, there wouldn't have been escalated.
So there was no other option to de-escalate after that? Once a situation occurs, there is no de-escalation after that?
What are you asking?
After I stepped out of the vehicle, there was words back and forth. Did you feel like we needed to de-escalate further?
I don't feel like there was a further problem.
Okay, when we got to the jail, We walked in the jail. Why didn't you take the handcuffs off when we walked in the jail?
We don't take the handcuffs off, the jail staff do.
When you see that I was agitated, did you feel like that was a de-escalation situation?
You were in the custody of the jail at that point.
Oh,
I just needed my handcuffs to leave.
So you were assisting them when you placed your hands on me?
I briefly held your arms, your one arm, to assist them because there was just one or two people right there. So until they got more people, whenever they had more people over there, I stepped back and took my hands off of you.
You said they only had how many people again?
Originally, there was only like one or two people right there. That's why I was assisting. And as soon as more people came, that's whenever I stepped back.
Was I resisting them, or was I putting up a fuss or fight with them at this time when you intervened?
Yes, sir.
You stated that the reason you didn't take the handcuffs off when you came in the jail because I was in their custody. That means that your responsibility ended at the time, correct?
I'm not just going to stand there and watch somebody fight and resist from someone and put them in any type of danger. No, I'm not.
What does fighting and resisting look like to you? Like if you see somebody fighting and resisting, what does that look like to you in your own words? Can you paint the court a picture, please?
Resisting would be preventing them from removing the handcuffs is what was happening.
You stated that earlier I made the statements of I'm going to beat you up, B, correct?
Yes, whenever she was asking you to stop tensing up, that is what you said.
Was I speaking to you?
You said that out loud. You did not say that directly to me.
Oh, so
but
I
was
didn't
right
direct
there.
it to you. But you believed it to be towards you?
Absolutely.
You made a statement to me as we entered the jail when you said that I allegedly said that I am a threat. You made the statement. You said like you were threatening me, but it's cool. What do you mean by that statement?
If I recall correctly, you said something about not threatening, and I said it seemed like a threat to me, but it's cool. If I recall correctly, that's how it was said.
Yes, what did you mean by it's cool?
That it's fine. I mean, you're going to threaten me. Later on, you made very thorough threats.
Let's stick to the question I'm asking you. So what you said it was cool. Like, does that mean you feel harmful? Does that mean that, well, that ain't nothing, you're just talking, or what does that mean to you?
It's cool. You made the comment. It's cool. If that's what you want, do you want me to answer?
You can go ahead.
Okay. What I was saying is that it's cool. If you want to threaten me, then you can threaten me.
You just blew it off your shoulder, basically. Would you please use your words?
You stated you were a threat. I said it felt like a threat, but it's cool.
So you blew it off, yes, correct.
Not saying I blew it off. I'm just saying that it's cool. If you want to threaten me, you can threaten me.
Did you feel threatened at any time?
During that whole encounter, up until me leaving the jail, yes.
So do you normally laugh when you feel threatened?
Sometimes. A little uncomfortable.
When you feel uncomfortable?
Yeah.
So do you recall the statement, he's just acting tough, he's just acting bad? Is that normally like a fearful statement?
I believe that your demeanor changed from the time that we were coming in. Like when we went into the jail, your demeanor changed. And then when you believe that when they were trying to take the handcuffs off, you were acting completely different, yes.
Do you believe that I would actually retaliate against you?
I do.
You do?
Yes, sir.
So if you believe that, then why did you take so long for the charges to get filed for retaliation? It's 5 months after your arrest.
When they made me aware of that, I was like, oh, I didn't know that was something that could be added on.
So it took you 5 months to figure out that you felt in harm and fear?
No, I did not know that retaliation
Mr.
after
Vaughn,
the fact was a charge that could be used.
To explain that, she didn't bring the charge. The grand jury returned this indictment. So it's not that she went to a magistrate and obtained a charge 5 months afterwards. The new charge was added by the grand jury when it was considering the driving on a revoked license and the resisting arrest. They added the third charge after hearing testimony.
Well, what I want to ask her next was, why didn't she file it then? You had 5 months. She made it in her statement. Her statement was on time.
Then ask that question.
Okay. So once you found out about the resisting arrest, that it was a possible charge that you can charge, why didn't you file it?
I was well aware that resisting arrest is a charge.
You was well aware that it was?
Resisting arrest? Yes, sir.
No, I'm sorry, excuse me, retaliation.
I was made aware during the grand jury proceedings.
Okay, so that's why you didn't file it, but you just took note of it in your report. That was the only reason, just for future reference.
For the notation of the threats that were made in my original report, yes, sir, I notated in there just in case some further incident happened. Absolutely.
Okay, was there ever any actual retaliation?
I've never seen you other than that incident and in court.
No calls, no threats, no nothing, no contact whatsoever?
No, sir.
But you believe that a retaliation was still possible?
Absolutely.
After the first contact you made with me, how long did it take you to find out or find an alleged driving on revoked charge? Was
While
it
we
before
were-
you placed me in handcuffs or while we were at the jail?
While we were still on scene, I met with the magistrate before we ever went to the jail.
You met with the magistrate before we went to jail?
Yes, sir, at the police department.
Yes, that's when you found out it's at the jail?
No, I found out on scene that you were revoked from dispatch. So at the time that you were transported, I was well aware that you were revoked.
Okay, would you say it was about 15 minutes, 20 minutes maybe?
I don't know the length of time, but I know prior to you being transported, I knew that you were revoked.
Okay.
Did you run his driver's license before you placed him under arrest for resisting?
I believe that he was placed in handcuffs after I got him out of the vehicle and put him at the car. The point where he was transported to go meet the magistrate, I was well aware of the driving on revoked and the resisting.
Your report says you couldn't determine who the aggressor was in the alleged domestic.
I could not determine that, or the primary aggressor, and that an assault occurred for the domestic.
Okay. So absent this resisting charge, it's likely that you would have issued him a citation and let him go had he not done what you perceive to be resisting arrest.
Possibly so.
That's possible. If he's never arrested for resisting arrest and he's issued a citation in lieu of arrest and Ms. Dozier is allowed to drive away from that scene and Mr. Vaughn is never in cuffs and taken to the sheriff's office, in that scenario, he never would have been taken there that night by you either.
He was taken in custody for driving on revoked and for resisting. That was presented to a magistrate and probable cause was found, warrants were signed.
Understand that, but that's what I'm asking you. You would have been able to issue him a citation if not for the resisting charge, right?
You're asking a hypothetical situation. I'm telling you what occurred, that's what occurred.
Asking you, okay, then let me ask you specifically, had he not resisted, would you have issued a citation?
I could have possibly issued a citation.
Would you or would you not have?
Depends on the situation, the circumstances, how many priors he had.
The circumstances as they were that day, how would you have done it?
The circumstances, how they were that day, I would have done the same thing that I did.
Absent the resisting portion that you claim was resisting, and you came up there and nobody wanted to talk about you about what you perceived as a domestic, would you have just simply issued a citation to take out the resisting part?
Yes, sir. Like I said a second ago, that is a possibility that could have happened.
Okay. And had you done that, he would never have been cuffed up, would he?
Are you saying that he never would have went to jail? Is that what you're saying?
Yes.
Yes. If I issued a citation, I do not take someone to jail. That is
Okay.
correct.
Okay. At that point, you're not having to get your handcuffs back, are you?
No, sir.
And he's not making those statements, is he?
If we're not at the jail, that's a hypothetical situation. If he was issued a citation, we would have never been at the jail.
Okay.
That help.
And you have, count two, that resisting has been dismissed.
They elected to dismiss it, yes, sir.
Okay. You put your hands on him and all he said is, I'm not getting out of the car, right?
I
You
opened
opened the door,
and then we got out of the
put your
vehicle.
hands on him. At which point, Mr. Vaughn then showed you before you do that, before you do that, he had a weapon on him, correct? And he showed it to you. Was there a knife?
Yes, sir.
Right? So he was making sure that you were aware of the circumstances, right?
Yes, sir.
And so you didn't misinterpret his intentions that night, correct?
Misinterpret what intentions?
Well, he wasn't charged with an assault against you, and a knife can be considered a deadly weapon, right?
Yes, sir.
So if a suspect concealed a knife, then that would be a charge. He didn't conceal that from you at all, did he?
He made me aware that he had the knife.
Okay. And had he not, and you found that on him, that could be a basis for some sort of assaultive offense, right?
No, sir, I would not say that would be an offense or an assault to have a pocket knife.
But he was being cooperative and telling you in advance that he
After
had the knife.
After the fact, yes, sir.
Okay. And you did go out there and said, it's cool after he talked to you the first time, right?
After he told me that he was a threat.
Well, after what you say, he said, sure, if that's what you say, he said, you said it's cool.
Yes, sir, that was before the next two statements.
Okay. But at that point, you didn't feel threatened by saying if you said it's cool.
He said I'm a threat.
And you said it's cool, which would not be indicative that you felt threatened, would it?
No, sir.
Okay. You ran his driver's license on the scene at Dollar General
Yes, sir.
before you went to the police department?
Yes, sir.
To the magistrate. You had already had in your mind that you were going to charge him with an arrestable offense, right?
Believed that he was resisting and that he was driving unrevoked. He was taken in custody and that was presented to the magistrate.
And the resisting would nullify nullify the practicality of issuing a citation for the driving on revoked.
As I said, that's a hypothetical situation that he could have been issued a citation, yes, but there were other things I would need to look at.
At least it wasn't going to be because you were going to arrest him for the resisting. So it wouldn't have been a need for a citation anyway, would there?
Brad,
What do you-
I think you've asked that question about 5 times.
Yeah.
And I've not, believe Your Honor, gotten a direct answer.
She could have issued a citation. She said that. If she'd issued a citation, he would not have gone to jail. If he hadn't gone to jail, he might not have been charged with retaliation. All of that, you've made that point several times. Is there some other question that you want to ask?
The citation was less likely to be issued because she had what she perceived as an arrestable offense. I don't think I've gotten a straight answer to that.
Well, with the citation being issued, if I'm going to issue someone a citation, I have to make sure that it doesn't meet those exceptions. If it meets those exceptions that are outlined in the law, then I can't issue a citation and I should take them in custody.
Did you go through those exceptions that night?
No, I did not, because there was resisting and a
Okay.
driving on revoked.
I think that's what I was asking.
Is laughing sometimes a form of de-escalation?
Yes, ma'am.
You have been asked by both the defendant and elbow counsel multiple times on the timeline of when you realized that the defendant was revoked. Have you watched your entire video start to finish to be completely sure of the exact moment?
No, ma'am.
Do you even know if it's going to be on your video when you find out that he is revoked?
It could be. During the investigation, I ran, his license and I was informed, and I know that was before I would have went to meet with the magistrate.
Yeah, before you went to the magistrate, you found out that he was revoked.
Yes, ma'am.
But you don't know exactly what moment.
Not the exact moment.
So just throwing out the possibility, it is possible that it wasn't until you got to the police department with him.
Could be, but I would say that I knew on scene.
Okay. Nothing further, Judge.
The same question she just asked you about the time limit on the arrest. Would you say 30 minutes is roughly too long to find out if someone's driving on revoked?
I don't have a timeline on the amount of time that I knew that you were revoked.
Is there any policy or proper procedure that you go by to stay in lawful to a pullover?
Cannot detain someone for longer than reasonably necessary.
Once you decided to place me in the back of the car and we were leaving the scene, would you consider the investigation done, that was the reasonable time to end the investigation? Or should we take it to the police station and continue an investigation?
You were taken in custody and it was presented to the magistrate. I'm not sure what you're asking.
You're familiar with what you think a reasonable time would be, correct?
Depends on the circumstances.
Okay, so do you believe that when we left the scene that the investigation should have been concluded?
You were taken in custody.
When we left the scene and got to the police station, is it okay to continue to investigate?
Absolutely.
Okay. So what I'm asking you is, when we left the original scene before we got to the police station, you were not finished with your investigation?
You were taken in custody and you were transported there. If I didn't know that you were, I believe that I knew on scene, but if you're implying that I didn't know until we got to the police department, they were presented to the magistrate at the same time. Don't know that that's relevant.
I'm gonna ask you a permission, since Ms. Daniel Bryson brought up the video, that I'll be allowed to play the video in open court.
Do you have any other questions for this witness? You want to play the video in your response to the state's evidence, is that what you're saying?
Yes, sir.
Then we'll allow that to take place. I just want to allow the officer to step down if you have no other questions.
Judge, I think the video may be being played at an attempt at impeachment, and so if so, she would be able to respond after it's
All right.
played.
Well, let's bring the video up and let's get it hooked up and We'll allow it to play it.
All right, we're pulling the Judge in now. Hello.
How you doing?
Good. How about I come back here and talk to you real quick, man?
I'm not stepping out of the vehicle until you tell me the reason.
Well, we got a call that there's a domestic, so I just want to talk to you about
Call for a
what's going on.
domestic. What makes a domestic?
I got you. Somebody just called. Let me come back here and talk to you real quick. We'll talk about
I
it.
can't step out of the vehicle until I
You
commit the crime.
can't.
I reserve all my rights.
All right, well, let me tell you this. So Pennsylvania versus Mims case law says anytime I tell you to step out of the car, you step out
I
of the
know,
car.
but you also know.
Case law says, no.
Case
Case law says if I tell you to get out of the car, you get out of the car.
Can I have a
So
mail? Can
get
I
out of the
supervisor
car.
come to the room?
Well, no, they're coming. You're going to get out of the car when I ask you
don't feel comfortable right
to.
now because there's a female president, it's a male domestic. I've been in this
I'm
many
not.
times.
I'm just trying to talk to you.
Okay.
You're making this a thing.
No, I'm not.
Step it up for me. I don't want to talk to you. I want to talk to you separately, okay? That's how I want to do it. That's how we do domestics. We're going to talk to you separately. That's how we're going to go. So I'm going to get you to step out of the car. Look, this is
Am I
going
under
on.
arrest?
You're going to step out because I'm telling you to step out
Where am I
now.
going to stand? And am I under arrest
Step
before I
it up
step
for
out of
me.
my private vehicle?
You're not under arrest right now. I just need to
Then I
talk
have
to
no
you.
reason to step out. I'm still not under arrest.
Step out. You're going to go to jail for resisting.
I asked
The
you-
second I put my hands on you and you don't get out of this
I
car,
asked you
you're
a
going to
question.
go
You
for
did not answer
resisting.
it correctly. You know this.
There ain't nothing about it. I just
If
told
I'm
you.
not under
I
arrest,
just
you
told
have no
you.
reason to touch me.
Case law says if I tell you to get out of the
It's
car,
not
you get
about
out of the car.
case- if you say I'm
It
under
is.
arrest,
Get out of the car. Come on. Get out of the car. Get out of the car. I told you to get out. Get out of the car.
Don't get out.
Get out.
Well, hold on. Grab that before you
You're good.
touch me.
You're good. Ain't worried about that. Come back here and talk to me. Stop making this a thing.
Is that a male in that car?
Yes, there's two males in that car.
I want a
Go
male
up
to
here.
touch me. Please stop touching me.
Go up here. Go up here.
I want a male to touch me.
Yeah, there's going to be a male that's going to touch you. Put your hands on
Male,
your back.
please touch me. A male,
There's going to
please
be a
touch
male
me.
that's going to touch
A
you.
male, please touch me.
All right.
There are no females to touch me.
Dude, chill out.
See, you're being disrespectful.
You're
I'm not
being
even-
disrespectful. Sit
No,
down.
I asked you, am I under arrest? You said no. It ain't no shut up. Am I under arrest? And you said no. Then why am I
Did I
detained?
tell you to get out of the car? Did I tell you to get out of the car?
Am I under
Get
arrest?
out.
Am I under arrest?
Did I tell you? Now you are.
I reserved
Now you
all my
are.
rights.
Now you're going for resisting at minimum because I told you to get out of the car. You didn't get out of the freaking car. How many times did I tell you to get out of the car?
No, you're not.
No, he's not. No, you're not.
Right now, I think.
All right, ma'am.
He was arguing with me.
You step out and talk me away from the kids, please.
Yeah, we were just arguing.
I got you.
Another 15 years.
I got you. Well, there's enough that's already. Listen. There's a.
Your Honor, I would like to stop that right here and request now the time to ask some follow-up questions.
Officer will return to the stand.
Up to this point of the video that you've seen, did you classify that as the resisting that I was arrested for?
Yes, sir.
You would. At this time, did you go through the cite and release?
At that point in time, resisting. I asked you to step out. I told you when I had to put hands on you to get you out. And whenever I reached to get you out, you jerked away from me and then went to get out.
I jerked away from you in that video?
You pull away. As soon as I touch you, you pull away. I mean, if
You sure I wasn't reaching for a
court-
seatbelt that was across my chest to unbuckle the seatbelt and get out of the vehicle?
if you'd like, I mean, it's up to you if you want to play it again.
This is not an argument between the two of you. This is question and answer form.
Yes.
So ask your next question.
1 second, Your Honor, may I speak to my counsel?
Okay.
The segment of the video that we just viewed, so would you agree that I was arrested for refusing to get out the vehicle at this point?
For resisting, yes.
Yes, that's the only thing I was at this point in the vehicle. So there was no other offense up to this point?
At the point where we're paused right now, there was resisting. I said you're going to be arrested for resisting at minimum.
I believe that's all, Your Honor.
Thank you, Corporal. You may step down.
Yes, sir.
On this 336 indictment, the state has rested their proof on your motion to dismiss or suppress. You now have the option of putting on proof of your own. Do you wish to offer any proof?
I would like to call my witness, now at this point.
Who?
Jennifer Dozier.
All right. Tell her to come in, put out her cigarette, and come in now.
Excuse me, Your Honor. While we're waiting, is it possible that I can recall Javvens and ask one more question, please?
Days had rested and you had failed, but I'll allow her to come back to the stand for you to ask one more question. Officer Corporal, I would remind you to remain under oath.
Yes, sir.
At any time, did you Mirandarize me?
I'm sorry, repeat that.
At any time, was I Mirandarized?
Were you what?
Mirandarized. Did you read me my Miranda rights?
Not that I recall.
Not that you recall. Is that normal procedure too? When you're going to arrest someone to read their Mirandarization?
Not every time, no, sir.
Not every time. With this situation, would you say calls for it?
Pertaining to this arrest, no, I didn't need to. I don't think that I was asking you any questions related to resisting or driving on revoked. If I was asking you questions, if you were being interrogated, you would need to be advised of your Miranda rights, but you were not being interrogated.
Okay, thank you. That's all. Right.
Thank you, Corporal. Hopefully this time you can stay seated.
Yes, sir.
Dozier, I need you to come around to the witness stand, please. Mr. Vaughn, she is your witness, so you may approach the podium and question the witness.
Would you state your name for the record, please?
Jennifer Nicole Dozier. I'm sorry. I started this 2 days ago and it still hasn't cleared up.
Just pull that microphone to you as close as you can.
The night of this arrest for this case with Officer Jarvis here, do you remember that night?
At Dollar General.
Yes.
Yes.
When I was asked to get out of the car, I know you're saying your area of expertise. Do you believe that I pulled away from her or pushed or gave her?
Not to my knowledge. You stated that you wanted a male officer because you didn't trust female officers.
Okay. Was you ever, I'm trying to state this question the right way. Was you ever asked for your driver's license at the scene?
Not wrong.
You don't recall? So you don't know if you, so do you know if she ran your name or?
I'm sure she
to
did.
see if
They
you had?
usually do on like every call, don't they?
Okay. Did you have a valid driver's license that night?
Yes.
Is there any reason that you believe that that you want to tell the courts of why I don't trust female officers at the words you said?
You said you had issues with female officers before because of that domestic, and the female officers all came out a long time ago.
Okay. I believe that's all I have for you, Your Honor.
General Bryson, you have any questions?
No, Judge.
Thank you, ma'am. You may step down. You can have a seat in the courtroom, or you may go out in the lobby, or you may leave. Mr. Vaughn, you may call your next witness.
Yes, Your Honor, I don't have any more witnesses.
All right. Now, I'll hear you in argument. This is your motion, so you may argue your motion to suppress.
This is a motion to squash, to dismiss with prejudice, and suppress evidence. Citations under the Fourth Amendment, under the Tennessee Constitution, Article 1, Section 7, and TCA Code 47103A1, also under the Fifth Amendment for Mirandarization. Resisting arrest is a charge that my lawful actions does not fit the crime, therefore should the counts be dismissed, including the defendant not moving and directing obscene language at officers were not sufficient to support a conviction for resisting arrest. Also see Tennessee Attorney General articulating that passive interaction, specifically sitting in a car and refusing to exit, was not resisting. Again, a lack of cooperation in service or process is not a criminal offense, quoting Burgess. The defendant has no legal obligation to facilitate service or process or other cooperation with deputies by accepting service or process, quoting Burgess. His actions did not foreclose the deputy's opportunity to serve and to merely constitute a lack of cooperation with the deputy's chosen method of service. When a detention arises to the level of full-fledged arrest, the Fourth Amendment demands that the seizure be supported by probable cause. So a seizure occurs for probable cause under the Fourth Amendment when the police detains an individual under circumstances where the reasonable person will feel that he or she is not at liberty to leave. The officer continues detention of the defendant in the back of a locked police car has ripened the investigation, stopping to an arrest, and the officer did not have probable cause to arrest the defendant at the time the seizure was illegal. The police crossed the lines of the investigation into an arrest when they placed a suspect in the police vehicle for questioning ongoing beyond the bounds of a Terry, crossing into an arrest and constitution of seizure. The officer could have asked Jennifer to get out of the car to check her for injury since the concern was for her. These actions with her reaching in the window multiple times, placing me in fear, was just as every other interaction with females responded to domestic, its bias. State versus Daniels. However, neither the Fourth Amendment nor the Article 1, Section 7 of the Tennessee Constitution limits all contact between police officers and citizens. Instead, the Constitution provisions are designed to prevent arbitrary and oppressive interference with the privacy and security of the individuals.
That is your argument as to the resisting arrest charge?
Yes, sir.
Okay, I'm going to dismiss the resisting arrest charge, which I've already done before we ever began that hearing. So the resisting arrest charge was dismissed voluntarily by the state. So it has no bearing in this argument on this motion, except for whatever argument you might make about how that impacts the validity of the remaining issues. All of this that you've argued so far has had to do with resisting arrest.
Correct, Your Honor.
And if you want to address your motion to suppress as to the driving on revoke or retaliation for past action, then I'll be glad to hear that. But as I've said, I've already dismissed the resisting arrest charge on the state's voluntary motion.
Okay. Well, the rest of these, the arguments I have also stem from the resisting arrest.
That's fine.
And I'm using the resisting arrest as a reason for that we should move for dismissal of the remaining charges as tainted fruits. Let me see.
Fruit of the poisonous tree.
Yes, sir. Let me just go ahead and read some of this. I'm going to go on and read some of the retaliation right quick. All right, for example, Mirandaization is triggered only on custody. So once I was placed in the back of the police car, matter of fact, once I was placed in handcuffs, I was in custody. And Miranda should have fell into a factor. And
Miranda requires that the officer Mirandize you, if you want to say that term, that you be advised of your Miranda rights before any in-custody interrogation.
Correct.
Those rights include the right to have an attorney, the right to remain silent, and so forth. There is no statement that's been introduced at this point that where an officer has questioned you or interrogated you while you were in custody, and if they had, then without Mirandizing you, then the remedy is to exclude that statement.
Yes, sir.
But there is no statement. The statements that have been introduced were voluntary statements made by you, not as a result of questioning. That would therefore, Miranda would not apply.
Any encounter with an officer where they ask you any question is subject to Miranda, because any question that an officer asks can be considered as a listening and an illicit questioning that can be the fruits of a incriminating response. So Miranda would apply in this case, and I have this case here too, if you would like a copy of this, put in the record.
I'm well familiar with the Miranda rights and how they apply.
Before this clearly illegal arrest, the evidence and any statements used to make count 3 retaliation of past act never would have been obtained before that legal arrest, and also the fruits of the poisonous tree that stem from that arrest, which is the exclusionary rule, encompasses both the primary evidence obtained as a direct result of the illegal search or seizure and evidence later discovered. And that's all in support of the fruits of the poisonous tree. State versus Blair. The proper remedy for illegal arrest is the suppression of evidence seized as a result of the arrest, not dismissal of the indictment. Evidence derived from such a search is subject to suppression unless the state demonstrates by preponderance of evidence that the search and seizure was conducted pursuant to an exception of the warrant requirement. And I don't believe that the state will have enough evidence to support that finding, Your Honor. Here's my argument for retaliation. The state lacks evidence of lack of an intent. They don't have a intent. They can't prove an intent on my behalf that it was actually directed at the officer. They can't prove that there was an intent to do harm to her. There was no proof of none of that. There's no proof that any retaliation even exists. The act wasn't even motivated by retaliation. Just her touching me and telling her to stop touching me, that had nothing to do with her official capacity. The law requires that the retaliation be in response to an official act, testimony, an arrest, a prosecution. That was not the case here, especially when we just questioned her. She said that she gave me over to the custody of the jail. If I wasn't unlawfully committed into the jail facility to begin with, this just wouldn't even been a situation. The officer wasn't intimidated, nor was the officer harmed. Furthermore, the arrest wasn't even lawful, so the act of retaliation doesn't even apply. And any responses that came out of me should be counted as emotional and not expressive, nonviolent, nor retaliatory. My prayer is that the court sees my argument and move to dismiss all of it as tainted fruits stemming from the arrest itself, Your Honor.
All right, General Bryson, you may
Count three.
respond.
Judge, I'm going to approach this almost backward. The question that I see as almost deciding this is what would actually be suppressed here? So the state is going to trial on 2 counts, driving on revoked. So the evidence that the state would present in that is the officer seeing the defendant driving and the fact that his license is revoked. So no suppression would apply to either of those factors. Okay. The second count, or the second charge that is going to trial is the retaliation for past action, which doesn't have to be actual physical retaliation. The threat of retaliation is what's being alleged here. And to follow the defendant's logic, if this was an illegal arrest, by the defendant's logic that his statements should be suppressed as part of a poisonous tree, had he instead chosen to punch the officer in the face and commit an assault, that should be suppressed as well. He is essentially asking for permission to commit new offenses. This is not an interrogation with a confession. It is a new offense. And under case law, even if this were fruit of a poisonous tree, even if we were following down that line, new offenses are not going to be covered by that. They are attenuated from the original incident. And so we just can't go down that road and follow that logic that his new offense doesn't count. Because that's essentially what he's arguing. It doesn't count that I said these threats to her. We don't end up there. That logic doesn't work. So let's go back to this supposed illegal arrest. The officer, as she stated under Pennsylvania v. Mims, had authority to ask him to step out to investigate. Probable cause was determined on 2 different occasions, both by the magistrate and the grand jury. Judge, the state chose not to go forward on that charge because there's a difference between beyond a reasonable doubt and probable cause. But the officer had probable cause to make that arrest, and moving forward, she had probable cause to charge him for driving on a revoked license. Now, the question here is not whether or not cite and release should apply, because that's not what the officer was dealing with that day. Looking simply at what the defendant is asking to suppress, none of the applicable legal doctrines would require suppression of those things. For those reasons, the state requests that you respectfully deny this motion.
And I have to reiterate that for it to be a past act of retaliation, that I have to say something directly to the officer or the victim, Your Honor. And there is not one person or any proof that they can provide that I actually stated something straight directly to anybody. I'm just freely talking.
The evidence at this hearing is indicated for Officer Corporal Javvens has testified to as the reasons for her initiating the stop of this vehicle were to investigate a domestic violence situation. She approached the vehicle and began speaking with you. She asked you to step out, or the defendant to step out. The defendant refused after repeated requests. Why is that important? Because the court is well aware of the fact that there is a greater risk of violence or threat of harm to law enforcement in response to domestic violence cases than many other kinds of cases. But an officer who is investigating a scene has a right to request that a person step out of the vehicle. Refusing to step out of the vehicle, and according to what we saw, was what you could consider to be some sort of forceful resisting. The argument that there is no valid charge of resisting arrest because it's, of the circumstances and therefore the fruit of the poisonous tree, so to speak, would apply, implies that there was, or assumes that there was an illegal arrest for that. 39-16-602 of the Tennessee Code under subsection A says it is an offense for a person to intentionally prevent or obstruct anyone known to be a person to be a law enforcement officer or anyone acting in a law enforcement officer's presence and at the officer's direction from effecting a stop, frisk, halt, arrest, or search of any person, including the defendant, by using force against the law enforcement officer or another. It is no defense to prosecution under this section that the stop, frisk, halt, arrest, or search was unlawful. So it basically says that can be. Now, I understand the argument being made that you really didn't do much to resist, according to what you were saying, but there's sufficient case law that would support a finding of guilt, and that's really not the issue, because what we're dealing with is probable cause. Is there probable cause for an arrest? Don't confuse the fact that there is a lower standard for probable cause to make an arrest than there is for a conviction beyond a reasonable doubt, which is what you're arguing. Evidence was sufficient to convict the defendant of resisting arrest because the defendant ignored officers' orders to come out from underneath the vehicle and had to be dragged out. And the defendant then refused to place his arms behind his back so that he could be handcuffed. And the defendant struggled with the arresting officers before his investigator was able to place handcuffs on him. State versus Baker, a 2019 Court of Criminal Appeals decision. The application to appeal to the Supreme Court was denied. And that's found at Lexus at 2019 Tennessee Lexus 484, September 20th, 2019. So that, and that was supporting a finding beyond a reasonable doubt of sufficient proof for resisting arrest. In this case, the court is only concerned with whether there was probable cause for the issuance of the arrest, because if there was probable cause for the issuance of the arrest for resisting arrest, which clearly by this court's finding there was, then the argument you make about the fruit of the poisonous tree is actually irrelevant because it does not apply. But in any event, the officer had probable cause to stop the vehicle, had probable cause to interrogate the passengers in the vehicle during an investigation for domestic violence. Why require the driver to step out? Because under the circumstances with the type of charge, very easily that a person could have driven away and fled the scene with the victim of the domestic violence in the vehicle with him. Those are just concerns that the court is aware of that could have applied. They ask a person to step out of the vehicle sometimes for officer safety. There is nothing illegal about that. The resisting statute makes it clear that resisting an officer's directions to step out of the vehicle where you have to be dragged out make it a part of the statute. So even though the state has elected not to proceed on that charge, the fact of the matter is that there was probable cause for the arrest on that charge, and therefore, even if that charge was dismissed, there was probable cause that existed for them to initiate an arrest, in this court's opinion. As to the driving or revoke charge and the argument about cite and release, yeah, if he had stepped out of the vehicle and offered his driver's license to the vehicle without resisting, then he could have been cited and released at that point. The officer had probable cause to stop him and check his license and to check the circumstances during an investigation of the domestic violence, and could have checked his driver's license and allowed him to be cited and released. His actions on that scene, on that particular moment, are the very reason why that did not occur. As to the retaliation charge, this court disagrees with the interpretation that Mr. Vaughn makes of retaliation. 39-16-510 of the Tennessee Code provides for retaliation for past action. And it says, a person commits the offense of retaliation for past action who harms or threatens to harm a witness at an official proceeding, a judge, a district attorney general, an assistant district attorney general, an employee of the district attorney general, or a law enforcement officer, clerk, employee or clerk a juror or former juror or family member of any such person by any unlawful act of retaliation for anything the witness, judge, district attorney general, assistant district attorney general, employee of the district attorney general, or law enforcement officer, clerk, employee of the clerk, or a juror did in official capacity. The defendant made the statement, got some bullets for all of you after he was at the jail and was upset about being arrested. The other testimony today as he walked into the jail with Corporal Javvens was, I'm a threat for a reason. And then it was also testified that as he was trying to take the handcuffs off and be at the jail, that he made the statement, fuck no, I'm going to beat that bitch. This court is of the opinion that all of such statements constitute sufficient probable cause and sufficient evidence for the matter to go to the jury on a charge of retaliation for past action. Therefore, the defendant's motion to suppress and dismiss with prejudice as to docket number 336 is dismissed. And that will conclude this hearing today, and the remaining issues will have to be scheduled for a future hearing. Make sure that that the witness that was here under Ms. Dozier has given the proper contact information, and we'll go from there.
The grand jurors of Dickson County, Tennessee, duly impaneled, sworn upon their oaths, do present that on or about June 18th, 2022, in Dickson County, Tennessee, and prior to the finding of this indictment, Sherrick Vaughn then and there did unlawfully and willfully drive a motor vehicle upon a public highway in Dickson County, Tennessee, at the time when the privilege of the defendant to do so was canceled, suspended, or revoked in violation of Tennessee Code Annotated 5550-504, all of which is against the peace and dignity of the state of Tennessee. And the grand jurors aforesaid, upon their oaths aforesaid, do further present and say that on or about June 18th, 2022, and prior to the finding of this indictment, in the county and state aforesaid, Sherrick Vaughn then and there did unlawfully and knowingly harm or threaten to harm Officer Lindsay Javvens by any unlawful act in retaliation for anything Officer Lindsay Javvens did in an official capacity in violation of Tennessee Code Annotated 39-16-510, all of which is against the peace and dignity of the state of Tennessee. Signed by W. Ray Crouch, Jr., District Attorney General.
Mr. Vaughn, as to that indictment and to those two counts, how does you plead?
Your Honor, I would like to change my plea. I would like to plead guilty to count 1 and not guilty to count 2.
All right. Ladies and gentlemen, the defendant has pled guilty to count 1, so that count you will not have to consider in your determinations in this matter. He has pled not guilty to count 2, and we will allow that to be entered as a not guilty plea. We are now ready to proceed to the next step, which would be the opening statements, and we're at the noon hour. I would suggest that we begin after lunch with opening statements, and then we move to the testimony.
You are going to get a snapshot of the incidents that happened on June the 22nd of 2022. The defendant having already pled to driving on revoked, the state will be presenting proof in our case in chief only on the charge of retaliation for past action. Now, what you will hear in the proof is that on that night, Officer Javvens had a reason to stop and talk to Mr. Vaughn, and that Mr. Vaughn, the defendant, was arrested. You will be able to see the video of when he arrives at the jail and begins to make comments to Officer Javvens. Okay. You will be able to hear his exact words. It will be up to you to decide exactly what those words are. Some of the ones that will be fairly clear will be, I am a threat for a reason. Mr. Vaughn is going to begin to become agitated, to become upset. He will state that he does not want this officer, a female, touching him. He will say that if they take the cuffs off, he's going to break her jaw. He will make several comments that you will get to hear while Officer Javvens is there. And then later on, you will hear from another officer that will talk about comments later on. And all of those comments taken together will be the state's proof for retaliation for past action, which is the making of a threat against an officer for actions taken in the course of that officer's duty.
Mr. Vaughn, you may address the jury if you choose, or you may waive your argument. If Mr. Vaughn is going to address the jury, he must do so now.
Your Honor, I wish to waive open statement and reserve for defendant's case in chief.
All right, defendant has waived his right to make an opening statement, so General, you may start your proof.
State calls Corporal Lindsey Javvens. We are going to focus on the events once he is taken to jail. Are you and he the only ones in your patrol car?
Yes, ma'am.
Were there other officers on scene earlier?
Yes, ma'am.
So once you arrive at the jail, explain to the jury sort of the sally port and how it goes to take someone into the jail.
Yes, ma'am. So whenever you pull into the jail, you drive around the side. There's a front gate. You press a button, tell them what you're there for. They let you in the front gate. And then you go to another gate, and that gate opens. And then you go into a sally port, which is essentially like a kind of like a pull-through garage. And it's a secure area to bring whoever into the jail. So we were in that sally port area. That's essentially like a garage. There's a door right beside where you would park your car to enter into the jail booking area.
On the ride to the jail, was the defendant, describe his demeanor.
On the way to the jail, like when we first started driving to the jail, we had been joking around and talking. We had just had a pretty reasonable conversation at the police department. We were on good terms at that point in time.
Is that unusual when you're transporting someone?
Not usually. I mean, after a point in time, sometimes people will, start having conversation with you. Sometimes people are mad the whole time. It fluctuates.
And did he remain calm, or did he become agitated at some point?
He remained calm until we got to the sally port.
What is the first thing that you would pinpoint as him getting agitated?
Whenever he said that my name's not Lindsay, when he was getting out of the car, and then he said that I lied to him like all women do. He started getting upset about that, and he was like, he said that we had made peace, and then I had lied to him, something to that effect of that I lied to him about my name and that we weren't cool anymore, basically. And then as we start to enter into the jail, that is whenever he said, I'm a threat for a reason. I misheard him, so I said, what? You're a what for a reason? Or you know what for a reason? And he said, I'm a threat for a reason.
Is that the only thing he said that gave you concern?
No, ma'am. He looked at me and he said, laugh if you want to. You live in Dixon, Fairview, you talk too much, implying that I had told him too much information about myself.
Did he make any, did he call you by name during any of these threats?
During the actual threats, no. At one point, he did call me by name during the incident inside the jail, yes.
Was anything in his body language suggestive of who he was talking to?
Absolutely. There in several times he was speaking.
Objection, Your Honor. Speculation.
All right, restate your question.
I asked if there was anything in his body language that indicated to whom he was addressing with this threat.
Overrule the objection. She can testify about what she observed and what, that led her to believe, but that goes to the jury to determine whether or not that's reasonable interpretation for what she saw.
Officer, was there anything in his body language that indicated to who he was speaking about?
Yes, ma'am. So whenever he was speaking and he would say her, he was leaning towards my direction. One time he even looked at me. And there's another time that he's walking towards my direction and staring me down right before another officer grabbed him.
Do you recognize what I've just handed you?
Yes, ma'am.
What is it?
It is the disc that contains my body camera footage from that night.
All right, Judge, are you ready for me to begin playing?
We are ready.
Judge, for the record, I am beginning to play on the video screen time, so that would be the real date and time, at 22 hours, 27 minutes, and 8 seconds. And I may pause at points. I'll note that for the record.
Can we get out this way or on that end? Whichever one's easiest for you.
Your name ain't Lindsay.
That's my first name. My last name's Javvens. Javins.
So you just lying to me like all women.
My name is Lindsay.
I just gave you respect. I'm taking it.
Lindsay Javvens. Look, I try to be like first name basis with people. Lindsay's way easier to remember than
You're
Javvens.
supposed to do.
Yeah, like Lindsay's.
Same way y'all got that last time on the lawsuit. You're straight.
What do you mean?
I'm gonna beat you first, though. I'm gonna let you know. Don't play with nobody that's peaceful. You better get you.
I'm not playing with nobody who's peaceful. I was being peaceful until you wouldn't get out of the car.
Disrespectful as I was.
Come on, man.
I'm a threat, though.
Come on, man.
I'm a threat for a reason.
What?
I'm a threat for a reason.
You know what for a reason?
I am a threat.
Oh, you are a threat?
Yes, ma'am.
Okay. Well, I don't know how you mean that, but okay. What did I lie to you about?
You're playing with me.
I'm not playing with
I
you.
don't trust women for a reason, bro. Hey, for real.
I don't trust people that don't listen to me. When they were giving them. Look, how are you going to tell me we made peace and then start being mean
No, I'm
again?
just letting you know. I'm just letting you know who I am. It ain't no threat, not my kid.
You kind of just threatened me, but it's
Okay,
cool.
you want to, I'm sure I'm none of it. Feelings don't feel up your stomach or paper chips. Fuck feelings. That's what involved the whole array is your feelings.
All right.
That's your record.
You say something really spicy? I don't have a problem over here.
Ready to submit offline.
What?
He's ready to submit offline.
You still go through, you still put it in a supplement?
Yeah. Who's the sergeant in charge now?
It's Gonzalez.
Is it the light skin dude?
Huh?
Is he light skin? I call him light skin, okay.
Feels like you're like, you're gonna feel like you didn't know what you were walking into.
I'm gonna put my hand in there.
You looked a little scared.
Never scared. I'm not sure. I'm playing again.
Nobody else. I just get the fucking radio.
If he's in our.
Mr. Vaughn.
Have not received any of his score yet.
You can take those off.
Don't do it.
I would just try calling back in about 30 minutes to an hour. We won't know really anything
Mr. Vaughn,
about it.
I gotta leave.
Lindsay, that's your real name, you know what I don't talk about
If you do know what it is.
Take the cuffs off.
She's not in charge of these kids. I know that's it.
I need my.
Get this fucking guy. She's not none of that. Don't touch me, I know the charge me.
I'm leaving.
Yeah, you can call them, and then tell them we're goodbye, and they might have some other things to do. But otherwise, I would just call back in about a half hour.
Oh, what?
All right, listen, I'm just talking about, listen, you won't be cordial, we'll be frank.
Well, because that's my stuff. I need my
I
stuff.
don't trust her.
That's her cuffs.
Bro, I will put myself in your custody and we can go to this cell together. She needs to be away from me. I'm asking you not to take these cuffs off.
Mr. Vaughn.
Until I get away from her. Me and you can walk over there. Lindsay, tell her to leave me alone. I will not
However you
cause
want
you
to do
any
it.
trouble.
I just
Fuck the
need
rest.
shit so I can go.
Fuck the rest. Play with me if you want to and find out.
I'm sorry.
Go ahead and get the keys. No, you're not gonna move. I'm gonna remove these cuffs off you. Stop pulling back now.
Pulling back. Why is she touching me? A female shouldn't be
Stop moving now!
A female shouldn't be touching me, bro. Look, I'm in fear for my life. She should not be touching me.
Hey,
Alright.
nobody wants to hurt you.
Why is she touching me? I don't trust her. Get her off of me.
I hear you.
Please get her off of me.
Nobody wants to hurt you, just go with the flow.
So with the flow, get her off of me. I need her touching me. Y'all can handle me. I said I wouldn't.
Nobody's touching you anymore.
Stop pulling back, Sarah!
Fucking touch me.
She's not touching you!
She fucking touch me.
She's not touching you right now.
She's not touching you anymore.
She's not touching you. Relax.
She's not touching you.
Relax.
Her hands are off you right now.
I just told you I would. I'm gonna do no problem. She ain't got no goddamn reason to touch me. When I don't get broke, it's your fault. Give a fuck about the law.
Sorry. Hey, we're trying to get the cuffs off you. Can you stop tensing up, please?
Fuck no, because I'm gonna beat that bitch up. Dead on it.
Thank you.
Y'all think everybody playing? You laughing. You live in decent family. You talk somewhere. You get some problems. When you shake me up, bitch.
I'm sorry. He just wants to act bad since he's in here. He's perfectly fine the rest of the time. Just trying to act hard. Here's his copies right here. That's all he had, was just whatever was on.
Just shoes.
That's all he had. Didn't have anything else. Original call for domestic. He was threatening to kill his kid.
I am going to keep this queued up in case during his cross-examination, the defendant wants to play any portion of this.
All right, then we'll turn the lights on.
Did this interaction at the jail happen in Dixon County?
Yes, ma'am.
Did you have you had any interaction with the defendant outside of your capacity as a law enforcement officer?
No, ma'am.
These comments taken as a whole, did you mention this to another officer?
Yes, ma'am.
And that officer encouraged you to document these?
Yes, ma'am.
Why did he encourage you to document these?
He encouraged me to document the information.
Objection, Your Honor, speculation.
Overruled.
Why did he encourage you to document these?
He encouraged me to document it in my report just in case any further action happened, as if he did try to retaliate against me, did try to assault me or anything like that. Say if I, saw him out in public somewhere.
Let's talk about assault. You did not seek charges for him on assault that night.
That's correct.
And that's because he didn't hit you that night.
Yes, ma'am.
And that is a different legal charge than the retaliation.
Yes, ma'am.
Objection, Your Honor, leading.
Sustained. Don't lead the witness.
The charges of assault and retaliation, do those have separate elements?
Yes, ma'am.
Nothing further.
Is this this is the testimony you wrote, correct?
That is, yes, sir.
Here,
I wouldn't say it's a testimony, but it's what I wrote, yes.
Okay. This was because the video was, it was difficult for you to hear, correct? The reason you wrote this?
I wrote it out for myself, and then I shared it with Ms. Bryson, or General Bryson, sorry.
So you needed to recall it better for the jury, correct? Yes?
No, sir, I remembered what happened
How long ago was this?
in 2022.
I'm brain farting here, I'm sorry.
Okay.
So you wrote this out so that you wouldn't forget what happened for the jury, correct?
I wrote it out while I was reviewing my video. I think that it's important that I did that because there were a lot of direct statements that were made that I think the accuracy is important.
Okay, so you remember it from the video or you have firsthand knowledge?
Yes, sir, from the video.
Oh, okay. So you only remember the threat for retaliation from the video? I was charged with retaliation, correct? Retaliation and past act.
Yes, sir, that was presented to a grand jury and it came back with true bill.
So that wasn't the original charge, was it? That the reason I was arrested and taken to the jail, was it?
No, you were taken to jail for a different reason.
Okay. And you didn't charge me that night with retaliation or past act, correct?
No, sir.
Did I tell you that I was scared of women at any time during the traffic stop?
Yes, sir.
I did. Did you believe that to be true?
Not entirely, no, sir.
Oh, so you took it as joking or lying per se?
I didn't believe that you were scared of all women. No, sir.
Was there another female jailer present who had her hands on me at the time when these statements were made, when they were trying to remove the cuffs?
Yes, sir. Yes, sir.
And you didn't ever hear me say your name at all or direct that towards you, that I want to do anything to you?
You looked at me and you said, Lindsay, if that's what your name is, because you were upset because you thought I lied to you. And then during that time, between the two threats of breaking my jaw and beating me up, you called me a lying ass hoe or lying ass bitch, one of the two.
The video we just watched, you said he's trying to act bad because he was in there before and he was perfectly fine the whole time. You said that, right?
At the end, I made a comment that you were acting different than you were before we got to the jail, absolutely.
You were laughing too also, right?
Yes, sir.
So you felt no threat at the time at all that night, did you?
Threats were made to me, yes.
So you didn't feel threatened?
I did feel threatened.
But you're laughing during feeling threatened?
I think that a part of my job, we are frequently faced with fear that we don't show. I've been faced with life and death situations and I didn't show fear.
So you had no threats or interactions with me since then?
The only interaction I've had with you since then is in court.
I think this would be safe to say that I feel like these charges were a retaliation from you instead of from me due to the fact that you arrested me for illegally. Would you agree?
Mr. Vaughn, you are making a statement rather than asking a question. It has to be in the form of a question. You'll be allowed to testify if you choose to do so, but this must be in the form of a question for this witness.
Okay. Would you say that the original arrest was illegal?
No, sir.
What was your original charges you arrested me for?
Originally, you were charged with resisting arrest, stop, halt, frisk.
Hold on just a second, please. Ladies and gentlemen, step across the way, please. Okay, we're walking a fine line. You've asked her a question about the original arrests. The original arrests were for driving on a revoked license, third offense, and for the second count, which the court, I think, the state resisting arrest, which I think the state had acknowledged. My concern is that opening the door to the evidence coming in about you're having two prior, being driving on a revoked license, third offense, and that's why I wanted to caution Corporal. I just want you to, if you can answer his question about driving on a revoked license, just don't add that third offense part.
Okay.
Is that all right?
Yes, sir.
All right. Then that's the only thing. Any objection to any of that? Step back and talk to your advisory counsel. Brad, I'm going to give you some leeway and from these, but I'm not going to keep delaying this trial for you two to confer. So make it quick.
Excuse me, Your Honor, 1 second. I'm aware of the charges that I'm being charged with, and I don't want to hinder her from responding to my questions. I mean, they're going to have to know that what I'm arrested for anyways.
It's your decision as to how you ask. I'm just wanted to make clear that what you're opening the door for, and you go for it. You ask whatever questions you feel like you want. You've got counsel that's advised you, and now you're ready to go.
What was the original reason you arrested me?
Resisting and driving on revoked.
Was one of those charges dismissed?
The state elected to not proceed forward with one of them, yes.
Do you believe that I really was resisting that night?
Yes, sir.
I'm going to play some video footage.
Oh, you want to play the video?
Yes, sir.
All right. Mr. Spratt can assist you in that. Are you going to ask this witness, what is it we're watching so that the jury understand and can follow along?
This right here, jury, is the beginning of the interaction with Miss Javvens. I can't get it right.
Right. So you're going to show the body cam footage from the initial contact between you and Corporal Javvens?
Yes, sir.
All right.
Good. How about I come back here and talk to me real quick, man?
I'm not stepping out of the video until you tell me the reason.
Well, we got a call that there's a domestic, so I just want to talk to you about
Call for a
what's going.
domestic? What makes a domestic?
I got you. Somebody just called. Let me come back here and talk to me real quick. We'll talk about
I can't step out of the video until I
You
commit the crime.
can't.
It ain't no shut up. Am I under arrest? If you said no, then why am I
Did I
detained?
tell you to get out of the car? Did I tell you to get out of the car?
Am I under
Get
arrest?
out.
Am I under arrest?
Did I tell you? Now you are.
I reserved
Now
on
you
my
are.
arrest.
Now you're going for resisting at minimum because I told you to get out of the car. You didn't get out of the freaking car. How many times did I tell you to get out of the car?
Do your department have a de-escalation process or policy?
We're trained on de-escalation, yes.
Okay. Would you give me some idea what that looks like, or from your training? What did they teach you to how to de-escalate a situation?
It varies upon circumstances and what's going on. I think that talking to people, I feel like it's a de-escalation tactic of talking to people like, hey man, come out here and talk to me real quick so we can talk about what's going on. That explaining to people their legal obligation to do something and giving them prior warning of, if I have to put my hands on you, you're going to jail for resisting. I think all of those things give, de-escalation works two ways. Gives that person a chance to begin to comply.
Okay. You just stated that citing their legal obligation to do something, correct?
Yes, sir.
So you cited Men's versus Pennsylvania, correct?
Pennsylvania versus Mims, yes, sir.
Okay, so you're familiar with that case law, correct?
Yes, sir.
But you're not familiar with past act retaliation? That is a statute that you can charge somebody with?
What are you asking?
I believe earlier you stated that you didn't have knowledge of what the charge was, but you just took note of it in case something happened.
I took note of the threats. If you're referring to the last motion hearing that we had, when I said I was unaware that that was a thing, I was unaware that it was applicable to law enforcement. I didn't realize that we were covered under that statute. I thought that it was applicable for judges and DAs and things like that.
Yeah,
Or positions like that, I'm sorry.
Yeah, I'm sorry. I'm just finding it funny that you're familiar with case law, but not with.
I'm sorry.
If we could keep to questions instead of statements.
You're making statements, Mr. Vaughn. Sustain the objection. You may only ask questions.
Did I have a seatbelt on that night?
Yes, sir.
Did I have a knife or anything else on me?
Yes, sir.
Did I give you the knife?
You told me the knife was in your pocket, and I took it out and put it in the car before you got out.
Do you think that was a wise thing for me to do, to let you know I had a weapon on me?
I appreciated that.
Okay, did that make you feel at ease? You wasn't feeling threatened any type of way?
I appreciated that you told me you had a knife on you so we could remove that from your pocket, yes.
Okay. When you're arresting someone, is it procedure for you to tell them to shut up?
Tell people to shut up?
Yeah.
I mean, it's not typically something that I do, but in the heat of the moment, I may say things that typically aren't said.
Okay, so the heat of moment, would you mean like you were agitated maybe?
I wouldn't say I was agitated. I was at a different level than somebody who would have complied and got out of the car and just sorted things out when I first asked them to.
Would you please elaborate on a different level, please?
A different level as in my senses were heightened that something else might be going on, that something's wrong. I have those officer safety concerns in mind because you weren't acting like the typical person does whenever you make a stop and you say, hey, come back here and talk to me for a minute. That's typically not the response that we get.
What was the original call? What was your reason for pulling me over?
The original reason was for domestic. They called in and said that you were threatening to kill the female and the children. That person was so concerned about those threats, they even came to the scene to speak with me because she was so concerned.
And that's the charge you didn't charge me with, correct?
No, sir, you were not charged for domestic.
I have some more videos I want to play, Your Honor. We can move forward.
What videos are those?
I have actually off the same video. I got different parts of it I want to play for the jury.
All right. Mr. Pratt, are you going to assist you in that?
Yes, Your Honor, I believe he's got some marked, and I'll flow with him and let you know for the record where we're at.
What?
It's not besides the point when I'm in fear.
All right, man.
I'm in fear of females because in 2015, 5 females showed up to the scene.
Bro, come on now. Stop that. Stop that.
You have not been where I've been. I don't know you. You're a new buddy. I'm not, no disrespect to new buddy. I've been doing this for years.
Okay, so
no disrespect.
What happened at Walmart? Why are people
All I told her was shut up. I got a phone call, people that are very dangerous telling me that my baby mama had her mouth open on their situation. I said, baby, you cannot talk. And she's still cussing me. She's doing everything. But shut up, shut up, shut up. All I repeat.
Yeah.
I've been with her for 15 years. She still ain't learned shit up. I don't ever put my hands on her. I don't ever do anything. Look, I just bought that for her. It ain't even her birthday.
I didn't say you put your hands on
I'm scared of females. I'm just gonna let you know because females make situations worse.
Oh, yeah.
That's why you heard me keep asking for
But
help.
it sounds like you made the situation worse by yourself whenever I told you to get out of the damn car.
But you're a female.
Yeah, tell you to get out of the car and you wouldn't get out of the car. That's the bottom line. I explained to you. I explained to you the law. I explained to you. If I tell you to get out of the car.
Listen, man, when it comes to life,
That's the
law
problem is
means
you
nothing.
think. Oh, I'm sorry.
When it comes to my life, I'm sorry, but when it comes to my life,
okay, and that's why you go to jail.
I've heard that before.
Okay, and that's how you go to jail, is if you don't follow the rules, then you go to fucking jail.
All right, so would you consider this an investigation still into the domestic at this point in the video?
I had spoken to the female about the incident. I was attempting to speak to you about the incident, and if I'm not mistaken, it continues. And you said that, no, you just told her to shut up.
What I'm asking is this considered an investigation at this point in the video? This is what you're doing, correct?
Looking into the domestic, yes, sir.
Okay, are interrupting people while they're speaking, is that part of your training? Because you walked up in the video when I was talking and just started cutting
Judge,
people off.
again, questions, not statements.
The objection is to the fact that you're not asking questions, you're making statements. I sustain the objection.
Is interrupting people while they're speaking part of your training?
No.
I believe we just seen that in the video, correct?
Interrupting you from speaking to the other officers, is that what you're speaking of?
To them, including you?
No, that's not something that they train us on.
What about profane language?
No, they don't train us on that either.
I believe you just said in the video, you're going to fucking jail, did you not?
I believe so.
Okay. What about the response? It doesn't matter what you think. Is this the proper response to people when you're investigating a domestic?
It doesn't matter what you think.
Yeah. Oh, yeah, that was definitely in there.
I'm not 100% sure what that was in response to, sir.
I believe we can play the rest of that video now, Your Honor.
All right.
So blunt splitter, what is that? Temporary.
Blunt splitter, you see how that's disrespectful?
Yeah, what is that?
Charging?
I
I don't want to talk to you no more.
Okay, well, you're going to jail for resisting.
Resisting? I didn't do anything.
Did I tell you to get out of the car?
I told you I reserved my rights. I asked you the reason. That's my right.
Did I tell you to get out of the car? Did I? Why are you doing all that? Stand up.
I'm scared of you. I told you I'm scared.
Stand up. Quit acting like that's grown man, man. Act like a grown man. Come on, come back here. You're making this a thing.
It is. If you've been getting look in your life.
Yeah. Let me fix this.
What happened in the past is whatever. We're here right now.
What am I
gonna do? Beat the shit out of you?
I keep saying I'm scared of you.
You ain't scared of me.
I am.
You ain't scared of me, man. Come on. You are not scared of me. Get in this car. Oh, shut up. You are not scared of me. Like, not even the slightest bit.
You can't change my words. You can take them and do whatever you want. I am scared of you.
All right, get in the car.
You're a female. I'm scared. Y'all make whatever y'all want to make.
Get in the car.
I'm with a white woman. I'm a black man. I'm scared of you.
That shit don't mean a damn thing to me. I don't give a shit about color. Get in the fucking car.
You don't, but I do.
Okay, get in the car.
It's my life. You ain't been where I've been.
Get in the car. All the way in.
I'm trying.
There you go. Yeah. Okay. Told him to get out of the car. Explained to him Pennsylvania versus Mims, everything. Told him to get out of the car. Told him to get out of the car. Told him to get out of the car. I had to open the door myself. And then I had to carry him out of the car because we wanted to play games.
Roger that. So she's not being
She isn't being cooperative. He's not being cooperative. He doesn't want my services for his domestics. So
she said at the beginning, I said, look, we got a call dude who's starting to kill people. She's like, he's just talking shit. He wouldn't really hurt anybody. And then near the end, I was like, so to be clear though, like he did threaten me. She's like, I don't remember him saying that. I'm like, okay.
Will you do my paperwork for me?
Your DV? Yeah.
I'm sure one of us, he got a wallet here and all. You got a wallet in here?
A wallet? No.
You don't have an ID?
I'm not 100%. It's in your.
What's that right there? Is that your ID? Oh, okay.
That's my license.
I got you.
I broke it a little.
What's his name?
His name? Did he give it to you?
No, I haven't got it from you. He's terrified of females apparently. So.
What is his name?
What's his name?
Yeah. Okay, I'll go ask
Like,
him
I don't get
myself.
why you don't need.
I was just trying to get it from you because you're like a little more cooperative than he's being. So I'm.
I'm sorry about that. Like, I'm trying to. I don't want him to go to jail.
Is it what's tatted on your arm? Because that's kind of funny.
Well, I don't want him to go to jail.
Okay, well, he's going either way,
What
so.
was he going to jail for?
Can I see that real quick? I'll just use it right here.
Yeah, it's kind of broke.
For resisting, 'cause I told him to get out of the car, he didn't get out of the car. 146 Central, Tennessee D on ready. Will you try to get his info? Yeah. Thank you. 106-626-651. They're all good.
I lost her in about 3 weeks one time.
Listen, I'm not trying to be rude, okay? I'm not trying to be rude at all. We were called. They're saying it's threatening to kill you and the kids and everything else.
Ask them. Hold on.
No, you're good.
Ask them.
No, we ain't gotta do all that. What I'm saying is, I'm here for a reason. Like, all I gotta do is make sure that he didn't beat the shit out of you.
No, I mean,
or beat the shit out of the kids.
We're not bleeding. He can't even get back there to the
That's
kids
what I'm
because all the
saying.
shit and all. You
As
know?
long as that's not going on,
Like, no.
then I
He
give
ain't
y'all
put his
some.
hands on nobody. Yes, he talked shit. Yes, I talked shit.
That's
Yes,
what I'm
we
saying.
yelled. But he ain't put his hands on nobody.
It's not.
They're fine. We're fine.
It's not illegal to argue. Everyone argues. What I'm saying is, we don't have to make this a thing. Any type of situation like this, it doesn't matter who you are, I'm gonna separate the people and talk to you, okay? So that's all that was happening. That's why.
I think I went to school with you.
Yeah.
That's why we're here.
Oh, no problem. That's what we're doing.
Huh?
Do you look at her tattoo on his arm?
Shoot, you wanna tell us who he is?
No, he will, but. So his name was actually Sherrick. He pronounced it Cedric, and he spelled it like he didn't really give a fuck. Right? So I was trying to copy it down while he was doing it, so I was asking if it's spelled Sherrick. S-H-E-R-R.
You got a social? Just get a social, that's the easiest way. Go ahead, 146.
Yeah, this thing started out as a joke. It's just got out of control.
Careful. Did you get it? We get his social.
What's your date of birth?
I can't look you up on that. That's why I'm asking.
I will give you what you my social.
Yeah, that works.
That works. 475. 67.
That's your whole social?
475. 1250. I'm sorry. Like when I tell you I'm scared.
You said that's way too many numbers.
No, 470. Ask her, she knows.
I know, that's what I'm trying to figure out, man.
She won't tell you who.
It's tatted on her arm. That's kind of funny, but.
Which you mean you shouldn't ask me, bro? Like, we have no games to play. There's no problem. She told you. I told you.
What is?
No. So just because that name's on her arm, though, right?
That's me.
That don't mean it's you, though.
I'm
It
telling
could
you
be
on record.
a different family member.
That is me.
Okay, I believe that. I'm just saying, when I first saw it, I'm thinking that could be a family member. I don't
All
know.
my kids and everything.
Okay, so, all right. So, what's your date of birth? We'll just do that. It's easier. You know when you were born, right?
I can't tell you how old I am because I don't celebrate birthday.
2389. So you're 33, because I'm 33. We're both 89. Yep.
Did you get all that now?
613.
Let me do DV real quick.
Is there some relevance to watching her pull out the paperwork that we need? Stop the video.
Yeah.
I mean, I understand it may be an hour or more that we're going through this. I'm just trying to determine, is there some portion of this that is relevant to the issues that the jury has to decide?
Yes, I have some questions that pertain to everything that's marked. It shouldn't be much longer. What is?
Your Honor, my list shows about 8 more minutes.
All right.
terrified of me, apparently.
I mean, pretty intimidating.
Man's solid muscle. Not at all. He's like solid fucking muscle, man. Solid fucking muscle. Solid muscle.
That's probably.
That's different though, man. Come on.
Yeah. That's why it's very.
Yes, ma'am.
I'm the one who called.
Okay, yeah. Cool, perfect.
I even have my boyfriend on the phone who heard all of it.
Okay, what happened?
So you could tell she's pregnant, right? He pulls in, absolutely just screaming at her over who knows what. But then he's like, I'm gonna kill you and those kids behind you. And then he's like, I'm gonna get my sister.
Where was this at?
So
I'm in the parking lot?
Yeah, on the worker's side. I don't have any doors behind you, so it's like I can hear everything and anything. But he's like, I'm gonna kill you. I'm gonna get my sister to kill you. I'm gonna drag these kids. I'm gonna kill the kids. Talks about hitting her. Like I even have my boyfriend on the phone too, who can contest that he heard all of it too. He's just talking about killing her and the kids, and like I don't know how to describe it. Like pushing her kind of, like that nudge pushing her, and he was like slamming her and the doors on the car, and like just going at her.
Okay.
But like, and didn't you hear all that?
Do you need DV paperwork?
I do. That's what I was trying to do. You'll get that.
But like,
I started.
my boyfriend on the
finished.
phone. He heard it all too.
I don't think she's gonna cooperate.
Yeah, but she got in the car, so it probably was a normal thing. But like,
Yeah, but she's not being very cooperative. Like she won't tell me much. So, and neither will he. So.
yeah, but yeah.
So he was like threatening to kill the kids.
No, he was threatening to kill the kids. And like I was shit. I went and told my manager too, like what happened after I called y'all. But yeah, I saw the lights. I was like, that's probably them. So
Yeah,
I was like,
I did get him stopped, so I do appreciate you calling.
but he was like threatening to kill.
Do you happen to have your ID on your second log that you were my complainant? And that I had like legit reason to make contact with him, you know? Yeah.
Yeah, but he was like going at her. And like, don't get me.
Sweet. I appreciate you calling for real.
Like, yeah. No, other people saw in the parking lot.
As far as like putting his hands on her, you just saw like he's kind of doing that, like
he was
shoving,
nudging
pushing
on
her.
her. But then when they got in the car, you heard her scream, and then like they drove away fast after that. And that's when I went inside to go tell my manager, if like a cop comes and talking to me, like y'all know that's not me.
Yeah. Yeah, that's
so like that shit was he got like hold of her.
What's phone number for you?
615-587-4057.
Cool. Yeah, the way it kind of sucks, like with domestics, that people don't want to like tell me what happened, and I didn't see it myself. I can't do too much about it. But yeah, he's going to jail for something else. So.
No, but yeah, I didn't know what to do because I didn't know like in the heat of the moment. It was like I'm right here, they're right there. He was like walking towards me and like kind of like are you listening type thing, and I was like ignoring him on the phone with my friend. I was like acting like I was talking to my friend. I was like, hey, I'm going home, I'm clocking out type thing.
Yeah, I got you. Well, cool. I appreciate you coming down here and talking to her real quick. You have a good one. Yeah. threatening to kill her. And that was a complaint that just came down here.
Really?
Said that he was threatening to kill her and the kids. Like, she was like all shook up. She was like, he was like doing like that nudge kind of push thing. And they both got in the car together and she started screaming. And then they drove off real fast. I don't really think that I have enough because she's not going to cooperate. She won't tell me any of that.
You know what that is?
It's supposed to be a cap repair. When I first pulled it out, I thought it was a blunt splitter. That's what it felt like. That's what it looked like before the light was on. It's like, that's a kid.
Just terrified of it. Every time you keyed up, we couldn't hear what you're saying, and I'm like,
Probably because he was yelling over me. Yeah, sorry. I was asking y'all to step it up as I was trying to do because, like, as soon as I walked up there, he was.
We were all the way out on West Crab Creek, almost to Lena, to serve that warrant. And then I'm like, there's nobody else. So we were already coming priority, but we were so far out it took a minute.
Yeah. I was trying to ask y'all to step it up, but because I didn't know y'all were coming hot.
Already.
Yeah, I didn't know y'all were still coming hot, but yeah. Because I knew that was about to escalate. I expected him to whole lot start acting a fool. Well, I don't think she's gonna cooperate. So. Ask him if he wants his denture stuff or whatever this is. Did you want this going with you? Or you can put it in the car?
You want that stuff?
Your repair kit thing?
We'll take your silence as a no, so yes or no. Oh, so yeah, I was putting a.
Yeah, did you want this to go with you? Give it to her. Do you need anything else out of the car?
No, I want you to let me out.
Cool. There's that. He told me to just give it to you. It's like some kind of repair thing, something.
Oh, it's for his tooth.
Yeah. Can we do all that?
Question you need?
Cool. Give her a oh, you haven't read it yet?
I haven't.
Okay,
No,
so like,
I read it. I
Boogeyman,
literally just finished it,
yeah,
so.
we went over. Like I went over. I did have an ex-boyfriend that did like put his hands on it.
Yeah, I got you. Look, I mean, like,
It's been years ago, but damn, I cut my ear somehow.
who's this, man?
I cut it at work yesterday. Really stretched. This is
Oh, okay.
so it's just.
So, I mean,
I don't want to get blood on
my thing is that I got people telling me a completely different story than what I'm being told by both of y'all, and that's cool.
I mean, I told you, you can ask them if he threatened to kill me and them. Like,
Yeah, it's cool.
I can't even get back there to him because they got a chicken.
I got you. Well, it's just so concerning
Well, I
about
have a
how
conflict
aggressive he apparently was being with you. So, but if you don't want to cooperate,
I'm gonna be
that's-
real, like
that's
right now I told him, if he did, it would be a totally different call. It wouldn't be a domestic, it would probably be a murder. Because I'm just not going.
All right. Well,
I can handle myself.
I got you. All right.
In this video you just seen, you said, stop making this a thing. What do you mean by stop making this a thing?
So you were making the situation into something it didn't need to be.
Would you say arresting me for a false resisting arrest, be making it a thing?
What are you asking?
Arresting me falsely for resisting arrest, would that be making it a thing?
I didn't falsely arrest you for resisting arrest. Probable cause was found on several occasions, actually.
Would it be making it a thing to arrest someone and not cite them when statute requires a citation?
A citation's not required for resisting arrest.
So I could have continued the resisting arrest after a citation?
Is that a question?
Yes.
What's the question?
So I would have continued, the incident would have continued if you would have cited me
Cited you for what?
for resisting arrest?
We don't cite people for resisting arrest.
You stated to the arrest and the other officers that you called for backup, you had to drag me out of the vehicle. Did you have to drag me out of the vehicle?
Did I assist you out of the vehicle? Yes, absolutely. You can see where I'm holding pressure on your arm to get you out of the car. And you're holding up on several times and you jerked away from me at the beginning, and it wasn't to take your seatbelt off.
So it wasn't to point out a knife on me or anything like that, or take the seatbelt off? That's what you're saying?
So I grabbed your arm and you pulled your arm away from me. Then you placed the cigarette in your mouth. Then you decided to take take the seatbelt off. And then you started getting out. You were hesitant. I'm pulling on your arm. And that's when you were like, hold on, I have a knife in my pocket. And I took the knife out of your pocket. And then you got out of the car, We began walking back to the car. I was holding your arm, and you again jerked to put your hands in the air when you were asking if those were male officers that were arriving on scene.
The resisting arrest charge came for not getting out of the car, correct?
Resisting arrest from the whole incident of not getting out of the car and me having to assist you out of the car, yes.
Okay. Separating me to address a domestic, is that your only method of addressing a domestic? Or was that your chosen method?
It was the method that I chose that made the most sense. You're the driver of the vehicle. That keeps you from driving the vehicle away with the potential victims in the car. I don't know what's in the car, if there were weapons in the car. I have all of these officer safety concerns due to your behavior and how you're responding to me and how you're acting. So the most reasonable thing would absolutely be to remove you and come talk to you instead of removing everyone else from the car because you didn't want to get out.
How many other people was in the vehicle?
Oh, you had children in the vehicle and she was in there.
Can you give me a count of how many people was in the vehicle?
I do not have a count of the number of people that were in the vehicle.
So you pulled me out the vehicle and you can't even remember how many people was in the vehicle?
Well, she was in the passenger seat, and then there was a huge aquarium in the typical area where someone would be sitting as the passengers, and then the kids were in the very, very back. I'm not sure the number of kids that were in the very, very back.
You sure there was nobody else in the vehicle?
Not that I observed.
So you secured the scene for your safety by pulling me out the vehicle, but then searched the rest of the vehicle?
Didn't search the rest of the vehicle.
You didn't want to see if there was anybody else back there, maybe some potential weapons in there, weapons of mass destruction, anything in the vehicle?
I separated the parties to investigate what was going on.
Okay. I mean, you were saying for officer safety, you took me out the vehicle, but I'm figuring officer safety is checking to see if there's any other harm in the area.
You're no longer in the car. You no longer have access to those things.
Oh, so I'm the only threat on the scene.
You were removed from the car so I could speak to you. You were the person that I was dealing with.
So I was as soon as you got to the scene, so it sounds like to me that I'm the person that you were targeting. Is this true?
Vaughn, you're making statements again.
I'm sorry, Your Honor.
You must ask questions and not make statements.
Did you ever check the female on the scene?
Yes, sir.
You did?
Yes, sir.
You patted her down?
Oh, did I search her?
Yes.
You said checked. I thought you were asking if I checked her license. I'm sorry.
Oh, yes. Did you pat her down at any time?
I don't believe so.
Okay, you didn't feel the need to?
No, sir.
Did you check her driver's license?
Yes, sir.
Okay, what about the other witness? Did you check her driver's license?
What other witness?
The witness that pulled up at the back of your vehicle.
Judge, at this point, I'm going to object to relevance.
Sustained, that's not relevant.
The relevance being that I was also arrested for driving on revoked, Your Honor. And
how is checking the license of the person who came to the scene relevant to whether or not you were charged with driving on a revoked license?
because it seems like I'm the only person that got checked for anything at this scene, Your Honor.
I am sustaining the objection as to relevance. In this court's opinion, it is not relevant whether or not they checked the driver's license of the person who came to the scene.
Okay. You said there was some other people at the scene. Did you say there were victims, I believe? That where threats were made towards them, so I don't know what you call them, but there was other people at the scene, correct, that threats was made towards?
Yes, sir.
Okay, did you have a question now?
It's my understanding they were children. Typically don't ask questions of children. It's already, traumatizing to a kid that's dealing with police in general. We've had this whole ordeal at the car of you getting out. I did not see it necessary to have this discussion with the children. I spoke to the female who was the other party who was supposed to be being threatened.
Is that procedure, not question children, or that was your own opinion?
It varies on the situation of their age. A lot of things go into play. A lot of times we do not question children.
What would you say their ages are?
I don't know their ages.
You never spoke to them out, did you?
I didn't speak to the children. I said that.
Okay. So teenagers, do you think they're old enough to be questioned?
Judge, I'm again going to object to relevance.
Sustained. It's not relevant. You were not charged with domestic violence, and as a result of that, a lot of this information that you're going to is not relevant to the charge that's being tried. The jury is only considering the retaliation for past action charge. So you might want to focus on that. So.
Yeah, I believe I am, Your Honor. I just don't think I'm asking the questions the right way. It all stems to run together. I'm just trying to prove that I was targeted in a matter that nobody else was, Your Honor. Okay, in the video, you also said, to the witness that came to the scene, you said, that's why this sucks about domestics. People don't tell me what happened, and I can't do nothing about it because I didn't see it. What do you mean by do nothing about it? What do you mean by that?
Well, the witness came to the scene and she obviously was concerned about what she observed. And I was explaining to her that sometimes victims of domestics, if those threats were made, for her to feel that uncomfortable to call police and show up to the scene, sometimes, if that all happened, sometimes the victims of domestic violence are not cooperated. They don't cooperate well whenever law enforcement comes to the scene. Yes, it sucks for that victim or for that person who may need protection if they aren't cooperative with us for us to help them.
Would you believe that the witness was very credible?
Yes.
The driver, the passenger in my vehicle, would you say she was pregnant?
I don't know if she was pregnant.
Okay.
Judge, I'm going to object again to relevance to this whole line of questions.
What is the relevance, Mr. Vaughn?
Just to challenge her observation of the whole scene, just to show that, once again, she was just only focused on me at the scene. She wasn't really investigating nothing, Your Honor. She had a whole objective of just wanting to charge me because I made her mad, Your Honor.
Well, I am sustaining the objection because whether or not the passenger in your vehicle was pregnant or not pregnant was not relevant to the proceeding that to the issue that we're dealing with and the charge we're dealing with. Sustain the objection.
Okay. Was there a witness statement made by the witness?
No.
Okay.
Judge, I'm again going to object to relevance. The investigation of the domestic, he is not charged with domestic. He has played the video. The jury can look at it as they want. There's just no relevance to this line of questions.
Sustain the objection.
Okay, let's go back to the video that Ms. Danny played for us earlier. You stated that you was assisting me to place me in a cell. This be acting outside the scope of your duties?
I wasn't assisting to place you in a cell. I assisted the other officer. They were trying to remove handcuffs from you, and only one arm was being secured by the other officer. Your right arm was not secured at all. So if you take those handcuffs off, both hands are free, and now we have an arm that's not secured. I'm not going to put anybody else in a situation to put anybody else in danger.
So, to put someone in danger, would you say you were the one creating the situation?
No, sir.
You have it was a body cam footage we seen, correct?
Yes, sir.
So it wouldn't show your face remarks or your smirking or anything else you're doing, correct?
No, you wouldn't be able to see my face.
Are you familiar with the jail policy for de-escalation?
I don't work for the jail.
Oh, you don't work for the jail, but you assist them at free will?
I never stopped being a law enforcement officer. I'm not going to let them be in a situation where they're placed in danger. Removing handcuffs where only one arm is secured, that's unreasonable.
So when you enter into the jail and you place me in their custody, does your custody end there?
You go into their custody, yes.
So I go into their authority, correct?
You go into their custody. You are booked into the jail and you're in their custody.
So you said you're not familiar with your policy doesn't say anything about your authority ending when you place me into the jailer's custody? Your policy for de-escalation or enter into a penal facility or nothing? It doesn't say anything about your authority ending once you place me into their authority?
I'm not sure what you're asking as far as that goes. I still feel obligated to assist if officers are being placed in an unsafe situation, yes.
Okay, so let me ask you this. Does your policy state that the only time that you assist in a situation in the jail is with their requests, that you just don't jump into nothing like that?
I don't believe our policy clarifies, but if it did, I would argue that I'm not going to place other officers in unsafe situations.
But with you present at the scene, and you seem to be the problem how are you placing the officers in a situation by just stepping back and stepping away?
You were making the situation a thing by escalating the situation because you would not let them remove the handcuffs. And then they were going to remove handcuffs and we were going to have an arm that wasn't secured. That seems like an officer safety issue to me.
I did not pull away until your hands touched me, correct?
If I recall correctly, you were walking towards me, staring me down when Officer Gonzalez or Deputy Gonzalez grabbed your arm and pulled you back.
The statement you have in your printout here that you typed, you said, on page 1, it states that right after you told me your name was Lindsay, you said, I just gave you respect. I'm taking it back, is what you said I said. You say I was joking or being serious at that moment?
I felt like at that time we were still on okay terms until we started the following statements that were made.
What about when I stated, no, I'm just letting you know who I am. It ain't no threat or nothing like that. You said, you kind of just threatened me, but it's cool. What did you mean by that? It's cool.
You can threaten me if you want to threaten me. Like, if that's what you want to say, you can say that.
So did you take it as a threat, or did you saying it's cool because I ain't taking it as a threat?
The statement is a threat.
How did you take it?
I took it as you were saying, I am a threat for a reason.
But did you take it as a threat? Like, was you in fear?
I think where the separation between a threat being made and an assault is the threat was made, not like an actual action happened. At that point in time, like, yes, kind of concerning that you said that, then with preceding statements added on top of that.
Let me ask you this. Was there a reason to be alarmed at that point?
I was caught off guard while you started talking about being a threat because we had been having normal, reasonable conversation before that.
Towards the end of the video, you said, you're laughing, you live in Dixon Fairview, you talk too much. Why were you laughing?
I'm not going to say, oh no, I'm so scared, because you are implying that you know where I live. I'm not going to show fear in that situation.
Did you actually charge me with retaliation of past act?
It was presented to the grand jury. I did not obtain warrants for that charge, no sir.
What was it? How many months away was that, like after the arrest, would you know?
I'm not positive on the length of time.
Say about 5 months after the arrest?
I don't know the exact amount of time, but if...
During that 5 months, did you receive any threats or run-ins with me or have any issues after that?
As I previously stated, I've only had contact with you during this encounter and in court.
Okay. Do you think it was necessary to put a past act retaliation on me after 5 months and no issues?
I think that it was applicable in the situation. Threats were made to me in the capacity of a law enforcement officer for doing my job.
You don't think it was just retaliation for the false arrest?
There was no false arrest.
Okay, so you felt the charge was necessary to be placed on me?
Absolutely.
Okay. Thank you, Your Honor.
Corporal Javvens, to be crystal clear, the person that we heard in that video making those statements to you that you identified as threats, was that the defendant, Sherrick Vaughn?
Yes, ma'am.
Could you point to him for the record, please?
Yes, ma'am. He's over here. Black shirt, red tie.
Judge, if the record would reflect that she has
The
identified
record will reflect she has identified the defendant.
the defendant's attitude from the beginning of the interaction, it goes up and is sort of elevated, agitated. And then we see him calm down. Does he ever get agitated again?
Objection, Your Honor, leading.
I don't think she's finished the question. I think she's giving a prefatory statement before she gets to the question part, but let me hear the rest of it and I'll consider your objection.
Does the defendant ever get agitated again like he is in the beginning before the interaction in the jail?
Overrule the objection. The statement she made was prefatory in nature to describe what she was going to ask.
Do we ever see him, or did you ever see him get agitated again other than what we see at the jail?
No, ma'am.
So we see moments of almost joking conversation between you and the defendant and other officers and the defendant.
Yes, ma'am. After the initial coming back, after he was in the car, the demeanor was completely different until we walked into the jail. We got into the side port.
I have nothing further, Judge.
Thank you, officer. You may step down. They may call your next witness.
Judge, I believe there is a jury out matter before the next witness.
Ladies and gentlemen, if you'll step across the hallway, let me consider whatever this issue is, please. All right, what is the issue?
For Corporal Stewart, our next witness. Make motion to exclude regarding statements pursuant to Tennessee's rules of evidence of 403 probative value substantially outweighs the prejudice effect. And I was in custody with no ability to carry out the threats. The statements was not made specifically at Javvens, who was named victim in the indictment, is not relevant to any fact about Javvens more or less true, so object to Rule 401 and 402.
You're objecting to the testimony of this of the witness who made the statements that, or repeated at a hearing earlier, that you had said you had a bullet for all of you or something on that order?
Yes, sir. I mean, he also testified that he didn't witness me state anybody's name. He just made an assumption that it was for all in law enforcement. There's no relevance to the statements.
So are you objecting to relevance, or are you objecting under the rule that exclude, I'm assuming you're looking at other, the rule of evidence having to do with other bad acts?
The Rule 401 and Rule 402, Your Honor.
All right, let me hear from the state.
Judge, I have a good faith belief that the officer's testimony will be that not only did he hear these statements, they were an hour and a half to 2 hours after the arrest and after Javvens would have left the jail. It shows not only a continuation of the anger directed at Javvens and other officers, but that continued anger shows that there may be an actual intent to carry it out, because once Javvens was removed from the jail and removed from his presence, he was still making threats to harm law enforcement, and they distinctly go hand in hand with the threats that he had made earlier.
The objection is made under 401 and
One more rule, Your Honor, of 403, and the intent was never carried out, Your Honor. It's not a factor in the naming offense, or the naming charge, Your Honor.
all right, now see, the objections are made under Rule 401, 403, and 404. 401 of the Rules of Evidence is the definition of relevant evidence. 403 is the exclusion of relevant evidence on the grounds of prejudice, confusion, or waste of time. Rule 404 is character evidence not admissible to prove conduct. There are certain exceptions, including other crimes. The court finds that the objection should be overruled because from the pretrial hearings that we had, the testimony of this witness is that he was dealing with the defendant at the jail, and that the defendant made statements that would indicate that he had intent to cause harm or made threats against other law enforcement, including possibly the corporal who testified in this case. My recollection was that he said, "I've got bullets for all of y'all." So if the crime for which he is on trial constituted by threats, oral threats that are made, then those threats that are made constitute evidence of the crime itself, and therefore they are not evidence of other crimes, but rather are evidence of the crime for which he is standing trial. It is extremely relevant, and therefore the relevance, because it is the very nature of the charge for which he is on trial, the very relevance of those statements that would have been made to go prove beyond a reasonable doubt, if the jury so finds, outweighs any prejudice to the defendant. That definition that the jury has to find is that the defendant threatened to harm the alleged victim by an unlawful act, that the alleged victim had been a law enforcement, and that the defendant did so in retaliation for anything the law enforcement officer did in official capacity as a law enforcement officer, and that the defendant acted intentionally, knowingly, or recklessly. So clearly, statements made at the jail after the incidents that we've seen that indicate that he has bullets, if that is the terminology, for all y'all, it is extremely relevant, and is, while prejudicial, it is outweighed, the prejudice is outweighed by the relevance which goes to the very crime for which he is on trial. Therefore, the objection is noted, the record is preserved, and I overrule the objection. You may call your next witness.
State calls Sergeant Justin Stewart.
You were actually out on scene assisting Javvens at the original call.
Yes, ma'am.
And that was the first time that night that you saw the defendant.
Yes, ma'am.
Did you see him again that night?
Yes, ma'am.
Let me just help you to the point that we're at. Did you go back to the jail later that night?
Yes.
Okay, so you served that warrant, You take that person to the jail. What happens next?
Once we concluded business with the subject that I arrested, who was cooperative, Mr. Vaughn was out in the, I guess you could call it the common area on the male side and booking, was still upset and made a comment that he had bullets for all of us or something to that effect. And I simply mentioned to Corporal, I believe at the time, Javvens, when we got back to the police department, she just needed to notate that in her report, just in case in the future, you know, she were at Walmart or wherever, and he were to actually try to follow through with those threats.
When someone makes a threat like that, is it common for law enforcement to note it in your paperwork?
It should be.
Did his remarks put you on edge?
Of course, yeah, it's always uncomfortable. That if not, I wouldn't have made it a point to go back and mention it to her that this is worth documenting. It's concerning. You're threatening, you know, officers.
And to the best of your recollection, what were his words?
I believe that it was, I have bullets for all of you, or I have enough bullets for all of you. That's essentially what it was.
About how much time would have elapsed between the end of Javvens' call and when you were there?
When I returned to the jail?
Yes, when you returned and you heard these statements from the defendant.
So I can guesstimate, or if I'm allowed to use my phone, I can get the exact time.
A guesstimate is fine.
Maybe hour and a half if I had to guess, ballpark.
So at least an hour, no more than 3 hours.
That sounds reasonable.
Thank you. Nothing further.
Mr. Vaughn, do you have questions for this witness?
Yes, sir. One moment, please. When you entered that jail that night, did you have your body cam on?
I would have whenever we entered with the other party that I had after the fact, if that's what you're asking about, the arrest warrant that I referenced.
Did you manually turn off your body cam?
Yes, once business is concluded with the person that we're interacting with, that's standard, yes.
And you testified previously that Corporal Javvens was not specifically mentioned in these statements, correct?
That's correct.
And you were also on scene when I was arrested, correct?
Yes.
But you're not named as a victim here today, are you?
Yes.
I believe that'll be all, Your Honor.
Any redirect?
No, Judge, may he be released?
Thank you, Sergeant. You stepped down and you are released. You can go about your business, or you may have a seat in the courtroom. All right, next witness.
That's the state's proof, Judge.
It has rested their proof, Mr. Vaughn. You need to consult with Mr. Spratt before we proceed.
Yes, 1 second, please, Your Honor. Your Honor, I believe we're going to need the jury out to take up some matters.
All right, ladies and gentlemen, I need to take up a matter quickly. If you'll step right across the way, hopefully this will not take long. Mr. Vaughn, you have a matter you want to take up?
Yes, 1 second, Your Honor. I'm coming.
All right, let's take it up.
Per Rule 29 of Criminal Procedures, I motion for a judgment of acquittal, taking the facts into light most favorable to the state. No reasonable jury can conclude that I am guilty beyond a reasonable doubt of this charge. No statements were made directly to anybody. There's no harm that was done to anybody. To add insult to incident, 5 months delay, there was no carry out of these allegations of the statements I made. The intent was never there. And I believe with all the evidence that I showed to the jury, they would be acquitted, Your Honor.
All right, thank you. You wish to respond, General?
And in a light most favorable to the non-moving party, the jury has heard multiple statements that he was going to break a female's jaw, that he was going to beat a female up. All of these taken in relation and in the context of the situation means that they were directed at Officer Javvens, and the jury could easily conclude that they are in retaliation for his arrest, which was done in her official capacity.
Motion for judgment of acquittal is a procedural issue where the defendant challenges the sufficiency of the evidence. And as Mr. Vaughn himself pointed out, I have to review the evidence in the light most favorable to the state, the non-moving party, and as a result of that, I find that there is ample evidence for the jury to find that the defendant has in fact committed the crime of retaliation for past action. All of the statements that have been alluded to and been introduced by the state could be interpreted. I think it's an argument that as far as the no harm, statute doesn't require harm. It requires a threat to be made against someone in law enforcement as retaliation for past action. And the argument can be made that, well, there was no present ability to carry it out and so forth, but the statute doesn't require that. So I find that there is sufficient evidence to overrule the motion. And now we move to the question of whether or not the defendant is going to put on any proof. Mr. Vaughn, I'm going to ask you to be placed under oath for the limited purpose of us conducting this, what's called a Momon hearing, and that is where I question you about your intentions. I'm going to go over it with you, and then if you'll raise your right hand, let the clerk place you under oath.
Fine.
All right, Mr. Vaughn, you are, understand, and I want to make sure you do understand, that you have a right to testify in this trial on your own behalf. And if you want to testify, no one can stop you from testifying. Do you understand that?
Yes, sir.
You also understand that you don't have to testify. No one can make you testify against your will. And if you don't choose to testify, the jury cannot draw any inferences from the fact that you did not testify. And in fact, the burden remains on the state to prove your guilt beyond a reasonable doubt as they've been instructed, regardless of whether you put on any proof or call any witnesses or testify. Do you understand all that?
I understand.
Have you talked this over with your advisory counsel, Mr. Spratt, and discussed with him the advantages and disadvantages of whether or not you want to testify?
Yes, sir, I have.
And do you believe it's in your best interest to testify or not to testify?
I believe it's in my best interest not to testify. Your
All right. Then upon your decision not to testify, I'm going to ask you to sign this form. Mr. Spratt, I realize that you are advisory counsel, but I'm going to ask you to sign as advisory. All right. Then have a seat, Mr. Vaughn, and we're ready to. Are you going to call any witnesses? All right. Then we're ready for the jury. All right, ladies and gentlemen, the state has rested their proof. Mr. Vaughn, do you have a witness that you wish to call? All right, call your witness.
I'll call Jennifer Dozier. You state your name for the record, please.
Jennifer Nicole Dozier.
How do you know me?
20 years and 3 kids.
Okay.
Pull that microphone towards you a little bit, please. There you go.
And we have 3 kids together.
Are you familiar with this case here today?
Yes.
The initial call that the police were called for, are you familiar with that?
So we were arguing?
Yes. What did they say it was when they got to the scene?
We were arguing in Walmart.
Okay. Are you familiar with the statements that were made, the reason they came?
I don't remember. It's been years.
The statements that were made were statements that I could cause harm to someone in the vehicle or to yourself. Do you believe that it was possible that I could cause harm to you?
No, not in that moment. We were arguing over a birthday cake.
Do you think I'm someone that people be scared of?
No.
Would you think I'd be the type of person to retaliate on somebody or dwell on things?
Not to my knowledge. Not that I've seen you do in 20 years, but.
One of the charges that I was arrested for was resisting arrest. I don't think that's a good question, but I'm gonna ask it. Do you believe I should have been charged with resisting arrest?
Well, no, but the charge was dropped, correct?
Yes, it was.
So.
Do you believe I should have been charged with that? Do you feel like I resisted in any way?
No.
From your own knowledge, there was other people in the car, correct?
Children?
Are they well capable of speaking English and understanding English?
Yes.
Do you think that if they were in fear that they would have spoken up if asked?
Yes.
You being their mother, do you believe my kids are in fear of me?
I mean, you're their father. They're supposed to be in fear of you at times, but.
Okay. Do you think that they would think I would harm them?
No.
Do you believe that the arresting female officer on the scene, do you believe that she addressed the issues to the best of her authority, you think?
I think she did.
You think she did?
I think maybe she could have called a male officer, but they could have been shorthanded that night. We don't know what was going on.
Okay. I think that would be all, Your Honor.
All right. State, have any questions?
Judge, I'm going to need a jury out before we have questions.
Ladies and gentlemen, if you'll step out across the way, I'll need to take up a matter in your absence.
Judge, I am giving the court notice that I am about to go into prior bad act evidence by the defendant asking this witness if he is capable of harm. He has opened the door to prior bad acts, including that he has previously been convicted of aggravated assault, aggravated robbery, a second aggravated assault, and a second aggravated robbery, if this witness knows that.
Yes, I am aware of that. I don't feel like
You just need to be quiet. I'm taking up lawyers are making a motion, so I'll have to be the one to deal with that. Door has been opened, not just open, but flung wide open and scotched open, it seems to me, by Mr. Vaughn when he asked the question about whether or not he would be the kind of person who would commit that type of an offense. So the rule, the court rule is he elected to represent himself. And with that, as I asked him, if he had familiarized himself with the rules of evidence and so forth, then it becomes imperative on his behalf to make sure he's familiar with. And of course, he's quoted in the pleadings he filed that we had motions on, numerous cases a lot of case law, a lot of rules. He's cited rules today. There's a line at which he's responsible for whatever he chooses to do. And he was advised he would be held to the same standard as a lawyer. Clearly, a lawyer who asked the questions that he asked about his client opened the door to the question of whether or not. Right now, the jury has heard this witness say, oh no, she doesn't think he's the kind of person who could do that kind of threat. That's a very material issue in the case having to do with a threat of retaliation for past action. The very gravamen of which is that he is capable of making that argument. So the state has the right to now produce evidence to show that this defendant, through this witness, is capable of such actions if he has in fact been convicted of other crimes. My intention is to allow this evidence to come in and to give the jury a limiting instruction. Their instruction will be that they are to consider this evidence only as it goes to the credibility of this witness's testimony regarding her belief that he is not capable of such, does not pose a threat and is not capable of that type of action. We're moving forward. The reason is, it's not going to make any difference whether you have 5 minutes. You can step there and have 5 minutes with him, but the fact of the matter is that we're moving forward with the questioning of this witness, and Mr. Vaughn, you can consult with him, but it's not going to change my ruling.
Your Honor, the questions that I were asking were pertaining to retaliation. And to the best of my knowledge, I believe she doesn't know nothing about the convictions of the sentences. I can ask her yourself for the record, Your Honor, if you want me to. Ms. Dozier.
No, we're not asking her any more questions. Okay. Now we're talking about the fact of whether or not this evidence should or should not be admitted. I'm giving you a chance to tell me why it shouldn't be admitted.
Because the questions I was asking was pertaining to harm to the children and pertaining to retaliation of past acts. She doesn't have any knowledge of my convictions.
You ask her the question.
So
ask her the question.
I'm asking her questions from the time that me and her was together at these charges, Your Honor. She doesn't have no true knowledge of them charges. Me and her wasn't even together when them charges happened, Your Honor.
Well, that may be, but she just testified on direct with General Bryson that she was aware of all of those convictions.
She wasn't given a copy of none of that. I don't believe it should be used, Your Honor.
All right, thank you. The court is going to allow the state to ask the questions, and I will simply limit your question to, is she aware of the fact that he's being convicted of aggravated assault and aggravated robbery? I still intend to instruct the jury that I'm allowing this information over the objection of the defense for the sole purpose of testing the credibility of this witness and her testimony as to, in response to the questions the defendant himself had asked about whether or not she thought he was capable of these things. Bring the jury in. Ladies and gentlemen, outside of your presence, I consider it an objection that was made to some testimony that was going to be offered. The state is about to ask some questions of this witness. I am allowing the state to ask questions that because of the fact that the defendant asked this witness questions about her belief as to whether or not he was capable. You'll remember what the questions were, whether or not he was the kind of person that would have posed a threat and so forth. So the state is now seeking to rebut that testimony by offering questions of this witness regarding some other matters. I'm allowing it to be introduced solely for the purpose of testing the credibility of this witness on the issue on her testimony in response to the defendant's question. You should not consider the evidence you're about to hear on the issue of guilt or innocence per se, but only on the issue of the credibility of her testimony about whether or not he poses a threat or he posed a threat and so forth. So the state may now cross-examine the witness.
Dozier, you testified that you and the defendant have been together for 20 years?
On and off.
On and off. And you have 3 children together?
I do.
What are their ages?
17, 15, and 12.
You testified that the defendant was not capable of harm. Just yes or no?
I did.
Okay. And you are aware that the defendant has previously been convicted of both aggravated assault.
Objection, Your Honor. Basis of knowledge, to ask the witness to lay a foundation. Basis of knowledge, Your Honor.
Overruled.
You are aware that the defendant has been previously convicted of both aggravated assault and aggravated robbery.
I was where he's arrested on. I didn't attend his court proceedings, but I knew he went to jail, of course, or prison.
Nothing further, Judge.
Redirect of this witness.
To the best of your knowledge, have I ever retaliated to anybody in these charges?
Not to my knowledge, no.
To the best of your knowledge, was any of them hurting any kids?
No.
Thank you, ma'am. You may step down. Mr. Vaughn, you may call your next witness.
Defense rest, Your Honor.
All right. State have any rebuttal proof?
No, Judge.
All right, ladies and gentlemen, you've heard all of the evidence that you are going to receive to be able to decide this case. The next step is for the lawyers or the state and Mr. Vaughn to make their closing argument. I would remind you that the closing arguments, both of the state and of Mr. Vaughn, are not evidence. They are not testimonial. They are not evidence. They are simply their argument to you about what they think the case has proven. So therefore, we'll let the state go first, and they have the right to go first, and also to close after the defense.
The state would submit the following statements demonstrate very clearly that the defendant knowingly threatened Officer Javvens for her arrest of him that night. I am a threat. I am a threat for a reason. Officer Javvens will say, you kind of just threatened me, but it's cool. And the defendant says, you can take it anyhow you want to. I don't care about none of that. When they begin to take the cuffs off him, notice what he said. Don't take them off right now. Don't do it. He says, Lindsay, if that's your real name, you done lied to me. I done told you I don't trust women for a reason. Stop talking to me. As they begin to get the cuffs off of him, he says, when her jaw gets broke, it's your fault. He then screams, lying ass hoe. He's accused only one person of lying. That is the officer. That tells you who he is directing this tirade at. It's directed at her because he's decided that she's lied to him. He then says, and ladies and gentlemen, I'm going to use his words because those are his words that you saw in the video. The female says to him after he says, lying ass hoe, the other female in the room says, hey, we are trying to get the cuffs off of you so you can stop tensing up, please. And Vaughn responds, fuck no, because I'm going to beat that bitch up. Bet on that. As he's going into the cell, he turns to this officer. He says, you laughing? You live in Dixon, Fairview, you talk too much. And then he continues on once he's placed in the cell. Ain't none of y'all safe without a goddamn badge. And then an hour and a half, 2 hours later, he is still speaking in the vein of these threats he's already made. As he says, where Corporal Stewart hears it, he's got enough bullets for all of you. Law enforcement should be able to do their job based on the facts and law in front of them and with no fear of retaliation for what they've done. That is why threats are enough. The officers told you they documented these because these statements might become relevant later on. That tells you the mental effect that these threats had on law enforcement. That tells you that they perceived them as serious, that they perceived the defendant could act on them. And under the law, it is the threat alone that is enough for punishment.
With all the evidence that is shown here today, can we say that we're happy about what happened? Can we say that we believe that we should be charged with something like that? No. Be honest, like, who hasn't cussed a police officer out before? You get pulled over for a ticket, whatever, I don't care what it is. They get on your nerves just like they get on my nerves. I'm an American. Did I do something? No. Did I speak in writing? That's debatable. It wasn't even direct. Throwing stuff out in the air, everybody in here probably said something. Every one of y'all should be charged with it if you ask me. With the evidence provided you, I've also shown that if it wasn't for the fact I was even arrested in the first place for a charge that they chose to dismiss, a charge that y'all didn't even hear today, this charge wouldn't even been put on me in the first place. I've also took the charge of driving on revoked, which I had very good arguments for that. Documents I could have put in today, but just to show y'all that I was being honest about the situation, just to gain some value with y'all, to be honest with you. Shorten this time with y'all being here so y'all can get back to y'all families. So looking at all the facts that were stated, the officer, there was no fear. This was just retaliation because she couldn't get me for nothing else. It's just simple as that. She's laughing, antagonizing. Really, you ask me, just going outside of her way, if you ask me personally. I'm hoping y'all see it in the same light I was seeing it in. You've heard the statement from my children's mother. She was present. The children were present. None of them feel any harm. They wanted to go home with me. You heard that in the video. I think this was blown way out of proportion. If I was a threat, I had plenty of time to do it. If it was that big of a deal, besides taking a note of it, why wasn't I arrested and charged with it then? Bottom line, it shouldn't be something to be dragged out. If you want justice, do justice then. It's simple as that. I believe that's all I got for y'all. Thank y'all.
Colonel Bryson, do you have any final say?
No, Judge, I'll stand on my argument.
All right, ladies and gentlemen, if you'll follow along with me. The defendant, Sherrick Vaughn, is charged in the indictment with the crime of retaliation for past action. The defendant pleads not guilty to the indictment and to the offense contained therein. The evidence and arguments in this case have been completed, and it is my duty now to instruct you as to the law. The law applicable to this case is stated will not be involved in setting the punishment. You may now retire for your deliberations. All right. Ladies and gentlemen, you now may retire to begin your deliberations, and the court will stand at recess pending the return of the honorable juries. Everybody present, we're ready for the jury. I'm told the jury has reached a verdict, so we are ready for the jury to come in, so bring the jury in. Ladies and gentlemen, I'm advised that you have reached a verdict. Is that correct? Would the foreman or the forelady please stand and let me ask this as to the charge in the indictment for the charge of retaliation for past action. How does the jury find the defendant, guilty or not guilty? Fine. If this is the unanimous verdict of all of you, would you so signify by raising your hand? All right, let the record reflect that it's been a unanimous finding that the defendant is guilty of retaliation for past action. Ladies and gentlemen, thank you for your assistance in this regard. So, ladies and gentlemen, you may leave if you'd like to exit through the doorway, and then the bailiffs will show you out. The verdict was guilty, so we need to order a pre-sentence report. My suggestion is, General, that we set Mr. Vaughn's case on Monday the 29th for us to not only set the pre-sentence report or the sentencing hearing, but also to assign a trial date for his next case that is going to be tried, and I assume that would be one of the 3 cases he has remaining. Do you want to give that some thought, and we'll go from there? Mr. Vaughn, I want you to consider this at this point. As I explained to you, you elected to represent yourself in this case, and I think you've had kind of a taste on what that is like. In the next trial, I believe there's much more serious charges of aggravated kidnapping and aggravated assault and so forth, if I remember correctly. And I want you to consider between now and Monday whether or not you would want to have appointed counsel, actual counsel representing you, or whether you continue to represent yourself. If you continue to represent yourself, then I will not likely, unless there's some showing of a reason to appoint an advisory or elbow counsel for the remaining cases. So we will bring you back on Monday, and we'll set trial dates on those new cases and set a sentencing hearing. We stand adjourned until that time.